Hansard is ready to go. We are live. Welcome everyone to the inquiry into the impact of the regulatory framework for cannabis in New South Wales by Portfolio Committee Number 1. This is the second hearing of the committee's inquiry into the impact of the regulatory framework for cannabis. I'd like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Jeremy Buckingham and I'm the chair of this committee. I ask everyone in the room to please turn their mobile phones to silent, including myself. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome, Mr. Broadbent. Thank you for making the time to give evidence. Could I ask you to please state your name and position title and swear either the oath or affirmation?
Thank you, Chair. My name is Nicholas Broadbent. I'm the Secretary of the New South Wales Bar Association and a New South Wales Public Defender based in Dubbo. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Mr. Broadbent. We appreciate that the Bar Association has made a submission. Do you have any remarks you'd like to make before we turn to questions?
Briefly, thank you. I'd like to thank you for the opportunity to appear before the committee on behalf of the New South Wales Bar Association, which is the professional association for practising barristers in New South Wales. I too would like to begin by acknowledging the Gadigal people of the Eora Nation, traditional custodians of the land on which we meet today, and I pay my respects to elders past and present. I'm the Secretary of the New South Wales Bar Association and, as I said, a public defender based in Dubbo. In my practice as a public defender, I cover an area bounded by Lightning Ridge in the north and Broken Hill to the west. Drug abuse of one kind or another is a feature of many of the cases in which I appear, briefed as I am for the most part in serious indictable matters for legally aided individuals. Features of my cases include a cycle of incarceration, poverty, low education and intergenerational trauma. Many of my clients are Aboriginal people. Some live in the most remote and most socially and economically disadvantaged areas of our state. The tyranny of distance is real, and what has been described as postcode justice in this forum arises in different forms and for various reasons. There is an incontrovertible association between drug use and disadvantage. The New South Wales Bar Association has long advocated for the decriminalisation of personal possession and use of currently prohibited drugs and supports all recommendations of the Special Commission of Inquiry into the Drug ICE. You've already heard extensive evidence of this and we agree with the submissions made in that regard. In the Association's view, the current stance of our criminal law towards use and possession of drugs has failed to have any significant impact on the prevalence of illicit drug use in New South Wales. Criminalising use and possession carries significant and disproportionate financial, societal and personal consequences. It encourages stigmatisation of people who use drugs as the authors of their own misfortune. It fails to recognise the factors driving most problematic drug use, of which there are many. These are all things that I've seen in my own experience as a public defender. We have provided written submissions and I would largely propose to rely upon those, so at this point, that's all I'd wish to say.
Thank you very much. We'll now turn to questions. Do you have questions?
Thank you very much.
Ms. McLaren-Jones. Mrs. McLaren-Jones.
Thank you very much, Chair, and also thank you very much for your submission also coming today. I've just got a couple of questions. I suppose I'll just kick off with you would like to propose that cannabis is treated differently to other illicit drugs. Could you outline the reason why, but also specifically how that would be the case, or what you would be recommending?
In relation to cannabis as a specific drug, we know very well that the incidence of cannabis use in the Australian adult population is quite high, far higher than other illicit drugs. In our submission, there's a problematic assumption that the way to solve a problem, as posed to the extent that it's posed by cannabis use, is to criminalise it. In our view, there's simply no evidence that criminal proceedings act as a genuine deterrent of individual cannabis use, and as the ICE inquiry found more generally in relation to drug use, the stance has failed to impact upon the prevalence of illicit drug use. And in our submission, that's particularly so in the context of cannabis. There is very little causal evidence in our submission supporting any criminogenic effects of cannabis use. Only 6.4% of people attributed offending to their cannabis use. And I can say anecdotally from my region, other drugs, and those drugs include alcohol, have a far larger criminogenic effect than that 6.4% of cases that might be attributed to cannabis. In respect of juvenile offenders, the evidence seems to suggest that cannabis use often postdates minor offending. So to the extent that it might be said to be somehow a gateway to further offending behaviour, that particular position in our submission is quite doubtful. Finally, and picking up on what others have said, assuming that the data on cannabis use is a reflection of what might be described as hazardous use, in our submission there has to be an assessment of what health and diversionary measures are in place for problematic use. Addressing harmful drug use must contemplate the broader social determinants of use. And in our submission, particularly on the question of cannabis, the legal system's an extremely poor vehicle to broker any kind of response to harmful use, and that's particularly so in the absence of any concomitant crime, which might be otherwise punishable in its own right. So that's broadly our position as to why we say that cannabis should sit in a different category, but I should also emphasise that the position of the association is one of decriminalisation generally and the adoption of the ICE inquiry.
Would you say that the current diversionary methods are they adequate and are they being utilised effectively?
There are a number of diversionary measures in place, as I understand it. These particular diversionary measures, I think they're often referred to as depenalisation. One of the difficulties that arises, and I can say this particularly from my region, is that the use of these particular measures appears to be somewhat haphazard. It also appears to be, it disproportionately seems to act against Aboriginal people, and that is because many of the criteria, so if I can just deal with, for instance, the cannabis cautioning scheme, some of the criteria which apply for a person to be eligible for a caution include that the offender has no prior convictions for drug, violent or sexual offenders, that the offender has to admit the offence, that they consent to a caution and sign a caution notice, and that they haven't been issued with 2 or more caution notices. We're aware of some recent research that demonstrates that a far higher proportion of Aboriginal people are deemed not eligible for that caution scheme. And the reason for that, according to that particular study, seems to be that, having regard to the criteria, that they're just simply not eligible. So that's a difficulty. There is also, in circumstances where some discretion is to be afforded in the way that a particular scheme or caution scheme might be administered, that in and of itself relies on discretion. It relies on police discretion. Now, police discretion may vary depending on locations. It may vary depending on the individual who is being dealt with, and also the individual who is exercising that discretion. And we have seen, as I understand it, some quite significant disparities in the way that cautions are administered. And that's one of the difficulties which arises. Just finally, in respect of the administration of a fairly new scheme, the Early Drug Diversion Initiative, it's apparent that there were very few people who were actually diverted into that scheme in the first place. So another issue with these depenalisation schemes is that if they're not in fact put into place, then that's a very problematic thing.
Putting aside the Bar Association's position on decriminalisation and looking at the criteria, do you think there is merit in a further review of how the criteria is used, and whether or not there is the flexibility? You talked about regions, obviously concerns around Aboriginal people being able to, I suppose, qualify in it. So is there ability for that to be flexible, or is it just too hard to be even implemented?
As I recall, a former police commissioner in discussing the issue of, I suppose, this issue of a discretion, suggested that unless there's clear guidelines, it can lead to real confusion. As I say, our principal position is one of decriminalisation, but if we're talking about depenalisation, then what that depenalisation needs to focus on is bringing as many people as possible within the ambit of eligibility. As I see, particularly in my region, one of the really significant barriers to these diversionary schemes that can have very positive effects for individuals is that by the time an individual may be eligible, they're already on what we might describe as the criminal ladder, and that's part of the problem. There is also a very significant issue in relation to the fact that when, for instance, we look at the cannabis caution scheme, it's necessary to admit the offence. Now, where there are difficulties, particularly with Aboriginal people, with trust in police, the admission of offending conduct is something that may indeed carry with it some real difficulties that arise from long-standing issues of trust, for instance. So, in our submission, any of these schemes really need to be focused on trying to improve the level of flexibility, but at the same time providing that level of certainty as to how a discretion will be exercised. That's a very difficult balance in my view.
Mm-hmm. Okay, happy to pass on.
Yeah. Thank you, Mr. Broadbent, for your submission and for coming along today to give evidence. The first question I had is, how could criminalisation be relaxed while not removed? Do you think there are any mechanisms that could achieve that? I know your position's for decriminalisation, but if we weren't to recommend that at this committee, what other steps could we take that could, in effect, relax it?
Well, if we're dealing with the issue of cannabis, for instance, one of the previous questions was directed at this idea that perhaps cannabis falls into a slightly different category, and we would embrace that as a proposition. So there is a need, I think, firstly on the question of decriminalisation, if it is to be something that is staged or in some way a modified process, we need to look at the actual harm that's being caused by a particular drug. As I say, the issue of cannabis is that it carries with it quite low criminogenic effects. And so there is scope to do it in that way. The other thing that I need to emphasise is that when it comes to issues such as drug trafficking and manufacture, we certainly are not of the view that decriminalisation in that instance is appropriate. What we're dealing with here is the personal possession and use of a particular drug.
So do you think, are you familiar with the South Australian Expiation of Offences Act? I mean, is that a mechanism that could provide a guide for use in New South Wales, where, for example, for people that are convicted of personal use possession quantities only, in effect, those convictions could be excluded under the Crime, Sentence and Procedure Act in terms of sentencing for other offences, for example?
As I understand it, the South Australian model provides for expiation on payment of fines for, I believe, less than 100 grams of cannabis. And there are other illicit drugs which are also eligible for that scheme. One of the important things about the expiation scheme in South Australia, as I understand it, is that under the, I believe it's called the Expiation of Offences Act, the expiation of an offence means that it is not something that can be subsequently used in further criminal proceedings. That is, the fact that a person has had an offence expiated cannot be used, and it doesn't constitute an admission of guilt. The process of expiation, as I understand it, permits an individual to, in effect, deal with a matter in accordance with what might be described as a civil penalty, without taking the matter any further and without, in fact, being prosecuted at all. That's a positive thing. As I say, it is something which ensures that, or that at least reduces the risk that the person enters onto that criminal ladder that I discussed earlier. One thing we need to bear in mind is that the use of fines disproportionately discriminates against low-income individuals. There is no doubt that there is a substantial correlation between drug use and poverty. And so one of the difficulties with perhaps, say, a fine-only approach is that the payment of fines is a condition of expiation. Yeah. In South Australia, if you don't pay those fines, then you proceed to be prosecuted. Yeah. So that in and of itself is an issue.
But, you know, other than that issue, you're saying it can provide benefits in terms of, in effect, removing what's a very small criminal offence, something that doesn't have a connection with other offending behaviour, from the criminal justice system, so that people have an opportunity to get their life on track. That's really what you're saying.
Yes.
Is that right?
I absolutely agree with that proposition. At the end of it, a criminal conviction is something that has substance. A person with a record is treated differently by a court to a person without a record. And there is a substantial amount of stigmatisation that flows from that. The other thing that I would say as well, and this is particularly so in our most marginalised communities, is that the more people who are convicted, the more that conviction and criminalisation is normalised. If everybody around you has criminal convictions or has spent time in custody, then the process of being convicted and spending time in custody becomes something which is quite normalised. So, as a general proposition, I'd be very much in favour of reducing that.
Thanks.
Mr. Broadbent, you were talking about the cannabis cautioning scheme being unavailable to a lot of First Nations people for a range of reasons. which of those criteria do you think, if we were considering reform of that scheme, would you prioritise if you were going to increase accessibility to First Nations? Is it the admission of guilt? Is it no prior offences?
As a general proposition, the fact of prior convictions for drug, violence or sexual offences is something which is quite problematic in the context of a caution scheme. Because if the discretion which is available under the cannabis caution scheme has not been applied in the past and a person has been convicted, then potentially they're not able to access that. So that's something that, in my view, needs to be a significant priority. The need to admit to an offence is problematic, I think, in the context particularly of young people. It needs to be made really clear in my submission that if a person is going to be admitting to some conduct or to an offence, that they have some certainty as to the outcome before they do that. One of the observations made was that the standard advice given to people is to say nothing, and that can be accepted. That often is the standard advice, but that might be against a person's interests because it leads to them being prosecuted.
When, for our edification, when and where is that admission required to be made?
As I understand it, the admission needs to be made before the caution is administered. So if a person is not willing to admit the offending, then that is an issue for eligibility. That's where the difficulty lies. I think that's the position.
And this happens like on the spot in a police station, or?
I believe that to be so, yes.
Okay, thank you. In your submission, you argue forcefully for the decriminalisation of the personal use of all illicit drugs, but when it comes to cannabis, you stop short of calling for legalisation, a legalisation regime. Yet other jurisdictions, Canada, Germany, parts of the US, increasing parts of the US, have moved that way. Why do you make that distinction? Why between legalisation and decriminalisation?
The position that the Bar Association adopts is in accordance with the recommendations of the Special Commission into ICE. So that's the first proposition. We support that position. What any scheme of legalisation, I would suspect, requires is a truly whole of government proposition. It would require a very substantial health response. It would require a substantial amount of investment into programs to ensure that harm is minimalised. In our view, the appropriate first step is one of decriminalisation. In the context of what has been said by other speakers, I believe Mr. Cowdery made reference to wearing two hats and expressed a particular view in relation to the merits of taxing, regulating and the like. That is a view which has some academic, certainly some academic and some real world experience elsewhere. However, in the absence of a very comprehensive whole of government scheme, really the decriminalisation, particularly of personal use and personal possession, in our submission is entirely attainable and what should be aimed for here.
Thank you. You were making the point about the link between disadvantage and drug use, and that you've said that the cannabis cautioning scheme is unavailable to First Nations people. What's the consequence, in your experience, for a young person of a cannabis a conviction for a cannabis possession. What in your experience, what can someone who's convicted of that? What are some of the negative impacts that they may experience?
Well, the first aspect is that the presence of a record in and of itself is something that is stigmatising. It may act as a deterrent to seek help if help is required. One of the aspects, particularly in regional areas, and this doesn't only apply to young people, it applies across the board, is that there's a substantial risk of what's referred to as secondary offending that can flow from a person being convicted of a particular offence. If conditions are placed upon them, then, so an example of that can be where a way a person travels might be somehow restricted. In a remote and regional area where public transport, for instance, is not available or not particularly well resourced, then that's something that can give rise to, in effect, secondary offending. Secondary offending is problematic because, particularly where it flies in the face of an order of the court, that is in and of itself quite a serious matter and is viewed as such. So very quickly, people's levels of criminality can escalate and increase. As I referred to earlier, one of the other issues, I think particularly for young people, is a change in expectations. There's a normalisation of criminality and punishment as being part of life. We've also made reference to the fact that criminalisation disrupts education. It can disrupt, and particularly if there's incarceration involved, it can disrupt working prospects. That's a very significant matter. If a person has a record, they may be prevented from doing particular jobs. They may also, as well, if we go, I suppose, take it to the extreme and deal with issues of imprisonment, imprisonment in and of itself may increase the risk of reoffending. People are placed in a position, particularly if involving drugs of addiction, where they are effectively withdrawing from those drugs in police or court cells, which are ill-prepared to support any such withdrawal. People who may not have otherwise been exposed to serious offenders are placed in an environment where they are naturally exposed to that. Drugs may be readily available in custody, and the use of those drugs is often done in the context of a high-risk situation, particularly associated with violence and also with high rates of transmission of blood-borne diseases and the like. And then finally, people who are in the criminal justice system may have more difficulty with accessing appropriate alcohol and drug programs in custody. So that's another aspect. And indeed, on release, there can be difficulties with that as well.
Thank you, Mr. Broadbent. Mr. Lawrence.
Thanks, Chair, and sorry I was late. I was caught on a train.
Not the Metro.
No, not the Metro. No, from the airport to here. Mr. Broadbent, I'm just interested in your thoughts on a pretty specific matter. If we were to recommend a liberalisation of the criminal laws that apply to cannabis, perhaps as an interim phase prior to a full decriminalisation of cannabis, in that interim phase, do you see any reason why police should be able to search a person on account of a suspicion of possession of a small quantity of cannabis? So to turn the question around, do you think there would be any problem in a legal sense or a policy sense of having a situation where cannabis possession remained a minor criminal offence, but there was no power for police to search a person on account of a suspicion of possession?
Could I start by saying that search as a general proposition is problematic in the context of where drugs are criminalised, and that is something which is likely to be exacerbated by measures such as the recent wanding legislation, where if a person if a person is wanded and the wand responds, then they're liable to being searched. Your question, as I understand it, is that if, in the context of, I suppose, a staged decriminalisation, whether the finding of a particular quantity of drugs, or of cannabis in this instance, is something that should be entirely decriminalised. Is that what your question?
No, so the question was more in a potentially interim phase where the application of the criminal law to cannabis is relaxed, might it be appropriate to remove from the Law Enforcement Powers and Responsibilities Act the power for police to search a person on account of a reasonable suspicion of possession of a small quantity?
I'm sorry.
So in
Yes.
effect, you would create an environment where it would still be a minor criminal offence to possess, but it couldn't be used as a basis to search.
In our submission, that would be an appropriate measure. As I say, one of the issues that arises, particularly with young people and young Aboriginal people, are the effects of proactive policing. There are powers of search inherently, particularly when we're dealing with things like wandering, cause significant problems. In our view, there is absolutely no difficulty with the proposal that you've put forward. It seems that if we are going to be moving towards a model of decriminalisation, then at the very least, the ability to search a person based on that suspicion should fall away very quickly.
Yep, and just on that, and I know we're very close to time, sorry, Chair, do you see any problem, conceptual, legal or policy, with a legal position where the default position for possession of cannabis is that a person is not convicted? So, for example, you could amend Section 10 of the Crime Sentencing Procedure Act so that a person can only be convicted if the court so orders. You could even condition it upon exceptional circumstances or something of that nature.
No, I do not. That seems to be something approaching a de jure depenalisation approach, as opposed to a de facto approach. One of the benefits of that, I suppose, if we were to compare it to, say, the Cannabis Caution Scheme, is that you're placing the discretion in the hands of a decision maker, the courts, who are applying the law every day and who are tasked with that specific job of making decisions about whether or not a conviction should follow. There's no difficulty with a statutory presumption against conviction. Statutory presumptions arise all the time in the criminal law, and in our view, that would be an appropriate measure.
Certainly. Thank you, Mr. Broadbent. Thanks, Chair.
Thank you, Mr. Lawrence. Thank you very much for your evidence today, Mr. Broadbent. That concludes our questions. We very much appreciate the Bar Association making a submission, and for you taking the time today to give your evidence. We very much appreciate it, and the work you do generally. So thank you very much. I don't think there are any questions taken on notice, but thank you again.
Thank you.
Morning, Ms. Lee. Thank you very much for taking the time to appear on behalf of the Redfern Legal Center. We very much appreciate your submission and your attendance today. Before we begin, could you please state your name and position title and swear either the oath or affirmation?
My name is Samantha Lee, Supervising Solicitor with Redfern Legal, and I affirm today, thank you. I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Do you have any remarks you'd like to make to begin?
Yes, thank you. I'd first like to acknowledge the Gadigal people of the Eora Nation and pay my respects to elders past, present and emerging. The country still has a lot of truth-telling and healing to undertake, especially after the failure of the referendum. I'd like to thank the Chair and Committee for inviting Redfern Legal Center to give evidence. I specifically want to hone in on strip searches for minor drug possession. I'd like to commence by telling the story of Jess. Jess is 17 years old. She attended a music festival. She was standing in the line just to enter the festival. She had saved up for some time to buy the ticket to enter this festival. While in the festival line, she was then tapped on the shoulder by a drug dog handler who told her that the drug dog had indicated. She was then pulled out of that festival line to a tented area. She was told that the drug dog had indicated, and she was asked if she had any drugs on her. She said she didn't. She said that a friend of hers had smoked some marijuana just before they'd come in, but she did not, and she did not have any drugs on her. They did not believe her, the police. They then asked her to take off all of her clothes, to stand naked with her hands against the wall. They asked her again if she had any cannabis on her, and she said no. They then asked her to squat. A female officer was in the tent with her, and they asked her to cough, and they asked her to pull apart her buttocks and lift up her breasts. She was crying at the time, still saying that she did not have any drugs on her. Nothing was found on her. They then searched her bag, and nothing was found in her bag. She was in tears. She was then told to get dressed and then told to leave the festival, given told to put on her clothes, was marched out by 2 police officers out of the festival, and her ticket was confiscated. This is on the basis of suspicion of minor drug possession, of having minor amount of cannabis on here. I'm mainly here today to ask you as the committee to change the legislation when it comes to strip searches and make it very clear that suspicion of minor drug possession does not meet the legal threshold to conduct a strip search. The majority of strip searches are conducted on the basis of suspicion of minor drug possession. The after effects of a strip search are lifelong, traumatic. The number of young people I have taken instructions from, both male and female, are in tears describing what has happened to them. I can only describe it as similar to taking instructions from someone who has been sexually assaulted. This practice cannot continue. We cannot allow New South Wales Police to continue to strip search someone on the basis of having minor drug possession, of having a minor amount of cannabis. The impacts of drugs, particularly a minor amount of cannabis, is very not as much as the impact of being strip searched. The impact of being strip searched is traumatic, long-lasting, and really does impact on that young person, even more than a minor amount of drug itself. It's antiquated law, and here's your opportunity today to stop that practice. Thank you.
Thank you, Ms. Lee. We'll turn to questions now from the opposition. Mr. Ruddick for the Libertarian Party.
Ms. Lee, thank you very much for your opening submission, your statement, which I found very interesting. Just talking more generally about cannabis use in New South Wales amongst First Nations peoples, would you say that cannabis use is increasing or decreasing over the last, say, 5 to 10 years?
I'm no expert in the amount of cannabis being used over a period of time, so it's probably best to ask someone else that question.
And do you think other harder drugs are an increasing problem amongst Aboriginals, or is it sort of stabilised?
Again, I'm no expert in the amount of drugs being used and who's using the drugs. I think that should be directed to someone else.
Thank you, Chair.
Thank you. We've heard this morning that the cannabis cautioning scheme is unavailable to people on the basis of the discretion of the officer, but also because of the various criteria that someone has to meet. Of those criteria, which is we've heard is an admission of guilt and so forth. Which of those criteria needs to be amended first to make it more available to people? So that's the question.
Well, I don't think there should be a limit on the number of cautions available to a police officer. And also the discretion, obviously, that allows quite what we've found, obviously, through the some figures around policing and cannabis, is that First Nations people are disproportionately over-policed when it comes to cannabis. So maybe there actually needs to be more rigour when it comes to the cautioning scheme itself.
But do you think that that some of the criteria, such as needing to admit guilt, need to be reviewed to make it more available as well, or the situation that if you have a prior conviction, you cannot avail yourself of the cannabis cautioning scheme? You're removed from it. Do you think that is problematic and?
I do think it's problematic, and I do think it needs to be reviewed. It does mean that very few people are able to make it through that cautioning scheme. And what we're talking about is a small amount of drugs, minor possession, and we're talking about young people. And if you limit if you don't look at the actual criteria for the cautioning scheme, you'll continue to narrow the amount of people that will go through that scheme and continue to see a disproportionate amount of First Nations people being allowed via that scheme.
We heard this morning from the Bar Association that cannabis and possession of a small amount of cannabis can be the first step that young people and First Nations people take into onto the sort of rungs of the criminal justice ladder. Is that your experience?
It is. I mean, my experience is first stage at the policing level, and those who are policed more are obviously given more offences and are given more cans. And the amount of money that you're looking at in terms of getting these young people through the justice system is ludicrous. At first you have the policing costing, and then you have the solicitors, youth workers, then you have the judges and the legal system, and all of this is for a small amount of cannabis. And then you have the impacts later on of them not having, getting a criminal record, that impacting on their employment. In terms of an economic scale, it does not make sense. And in terms of just compassion to young people and the fact that young people make mistakes like all of us did when we were young, it is a cruel system that does not allow for the obviously honest perspective that young people make mistakes. It's not a big mistake, and it should not impact their lives like the way it does.
Thank you. In your submission, you argue for a strict liability test for drug driving, effectively giving people a defence if they could prove they were reasonably believe that they were not breaking the law, as well as a defence for medicinal cannabis users. Is that offence and that issue something that's emerging more and more for people defending First Nations people and others in the courts?
Well, I think there's a lot of injustice with the roadside drug testing. One, it doesn't actually give you any indication how it's impacting on someone's driving level. It's not really equal to the alcohol testing system. and it's catching a lot of people out and putting them towards the criminal justice system unnecessarily. I think it's a very unfair system. We've had a recent court case where it seems to be that honest and reasonable mistake argument has now been taken out of the equation, which will make these matters before the court very difficult to win. And so you'll see more people ending up pleading guilty who may not even be affected by the drug that they took maybe 7 or 8 days ago.
There's a lot of evidence emerging from the United States that prohibition of cannabis and of other drugs had a racial element. It was designed to police and prejudice particular racial minorities. Do you think our prohibition on cannabis has a discriminatory racial basis, and effectively are these laws racist, do you believe?
Well, I think the figures speak for themselves in regards to the policing of cannabis. I think the majority through Boxer says that 80% of those who are given a cannabis offence are First Nations. This is a really high proportion. I think you can only conclude from that there is a racial aspect to the policing. And I think we need to stop denying in Australia that all levels of government have some kind of racial bias to it. Policing is not adverse to that, and we certainly see from the figures that it is coming out on the ground.
Thank you very much. Do you have a question?
Yeah, thank you.
Chairman, before I go to the government?
Morning.
Morning.
The drug summit is coming up, and hopefully there'll be a few good sessions looking at different regulatory frameworks for drugs, whether it's decriminalise or legalise in different situations. In terms of decriminalisation, like full decriminalisation, what specifically, how would you like to see that? We've got obviously, what is deemed almost decrim light in some ways since the beginning of the year. Data that my office has obtained suggests that the police aren't really using their discretion, if you like, to issue fines. It seems that most people are still being charged. But if the government was to go further, what type of a decriminalisation model would the Redfern Legal Center prefer to see?
Yeah, thank you for the question. We actually haven't yet come up with a position of the preferred model, and we're still taking a lot of information from more experts in the field, I guess newer and unharmed, about which model to take on board. But what we can say from our understanding at Redfern Legal Center is that minor drug possession, not just cannabis, but suspicion of minor drug possession is the most common way into a search. And I think as there was a question from Stephen Lawrence about, if you can stop the searches for minor drug possession, then you would stop a whole range of offending or cans being issued. It's very easy. Police are very, for good reason, I guess, quite skilled at starting a conversation around drugs and what's in the bag. And if you put some tighter rigour around the easy way into a search, I think you will see a pullback in the number of people before the courts. It is so easy at the moment to search someone on the basis of minor drug possession, and with this fine aspect, many cases are not getting before the courts, and police are not needing to prove whether they've actually met the legal threshold of reasonable suspicion, because someone just pays the fine. So there's real problems with a fine-based system, because you then are not making police accountable for proving that they have met reasonable suspicion. And the more you divert things to the fine system, the more you'll make reasonable suspicion less accountable.
Yeah, interesting. Thank you. And from your experience over the last 5 or 10 years, say, working in this space, I suppose that the data speaks for itself, but are less people going to prison because of ultimately cannabis possession in terms of personal use, personal quantity?
I don't have those figures, so I can't answer that
And people
question.
are still going to prison?
Again, I don't have those figures.
From
I
your
don't know.
experience, though, I mean, I don't necessarily need the stats now, but from your experience in terms of representing people.
Look, it depends on their criminal record.
Yes.
Yes, if they're on parole and they get pulled up for minor drug possession, then yes, they could still go back to prison.
Yeah, that's all for me.
Thanks, Mr. Burt. Mr. Borzak.
Ms. Lee, did I hear you say earlier in your evidence that the current law is being motivated by racial prejudice?
I said that all government institutions need to be aware of their racial position, and that certainly that police, through the statistics around those who are policed for possession of cannabis, First Nations people are disproportionately overrepresented in those figures from Boxer.
And why do you think that is the case? Because of naked racial prejudice, or because First Nations people use more marijuana or drink more alcohol, or what's the purpose, what's the reason for that as far as you're concerned? I mean, you are part of the Aboriginal, you're in the business of helping defend them and advocate for them, so perhaps you would see more of that than what happens outside of their community.
Yes, sure, but it's not our figures. It's from the Bureau of Crime Statistics and Research that shows that First Nations people are overrepresented when it comes to
I accept that
possession
because I've seen it myself.
of cannabis. So
I accept that, but
in
why
terms
is
of the factors that
why is
come
racial
into
prejudice
play,
got any being supported
that,
in those Boxer
there's
numbers?
Racial factors, obviously, that come into play. There's people that are obviously over-policed more than others. There's poverty, obviously, that comes into play. There's those who are more present on the streets. But certainly, you cannot deny, based on figures coming out of those who have been searched, those who have been strip searched, those who use of force is used against, First Nations people are overrepresented in those figures. And you cannot say that First Nations people are more likely to commit crime. I think what you could say is that First Nations people are more likely to policed more than anyone else.
And you're saying that's because of their racial background?
Of course, yes.
So where's the stats that prove that?
Boxer.
But the Boxer stats actually say that that is evidence that they are being racially profiled.
The stats show that they are disproportionately overrepresented in very minor offences.
But Boxer shows that they are overrepresented. There's no question of that, but not because of race.
Or maybe this inquiry can look at why they're overrepresented.
Now, have you looked at what other forms of abuse, personal or otherwise, may be part of why the use of marijuana is perhaps overused in the Aboriginal community? In other words, is there a coincidence for overuse of alcohol, for example?
Well, I don't know if it is overused. I mean, it's overcharged. Whether that ends up in convictions is a different question.
Well, I'm talking about other addictions. That's what I'm leading up to.
I'm not an expert in addictions, only in my experience.
But that's not
around
my
police.
question. My question is, you don't have to be an expert in other addictions. Do you see other addictions that happen besides the overuse of marijuana, for example? Do you see other drugs being overused with marijuana?
In the general population?
No, I'm talking about the population that you're representing.
Well, we don't just represent the First Nations population. We represent
Well, let's talk about the First Nations population.
Across New South Wales, actually.
We'll talk about the First Nations population because that's what you're here giving evidence about.
Yeah, but this isn't an alcohol inquiry. It's about cannabis. I don't know about the overuse. around other drugs.
You're just talking only about one thing. You don't know about the other parts of what may be happening in their community that may also influence addiction.
No, I don't. I'm not an expert in addiction. I'm only here to give evidence about policing when it comes to cannabis regulation in New South Wales.
So your evidence is that because they're overrepresented in the Boxar statistics, that is supportive of the fact that there's racial prejudicing and racial profiling going on by the police.
Yes, well, it's not a small overrepresentation. For example, First Nations people make up around 3% of the population in New South Wales and make up around 80% of searches in regards to cannabis, or they make up around 60% of searches when it comes to strip searches. So we're not talking about a minor increase. We're talking about a very significant, disproportionate amount of searches.
Ms. Lee, did you say 8 or 80?
I thought it was 80, but I could stand to be corrected on that. Yeah.
Okay, thank you.
But how does that support the contention that police are being racially profiling Aboriginal people?
Well, it based on my casework at Redfern Legal Center and in the instructions I take from my clients. It's also based on some research done by Tamara Hopkins in Victoria, who's done some research around racial policing and profiling. So it's not a concept I've taken out of the blue. It is a concept that's been quite researched, particularly overseas in America, but certainly here in Australia, there are papers that do look at racial profiling and policing.
Chair, can I ask a question?
Well, all right.
Just to
one,
follow up.
Yeah.
Ms. Lee, I just wanted to see whether you're aware of the report by the Law Enforcement Conduct Commission in 2003, the New South Wales Police Force Aboriginal Strategic Direction 2018 to 23, which found that in 2020, the LEC reported that 42% of young people on a suspect targeting management plan were Aboriginal or Torres Strait Islander. They recommended that police reduce that overrepresentation. Police accepted that recommendation. You're aware of that, just in terms of a fair bit of research, including, indeed, I think the police themselves accepting recommendations around overrepresentation of First Nations people in...
Certainly, yes. I'm also aware of the Mantis report, where I did represent the young boy in that case who was quite badly injured after a police chase out in regional New South Wales. I'm also aware of another case where the nipples of a First Nations person were pinched by a police officer with other police officers in an ambulance. I'm aware of many different researches by the LEC and by Boxer and by our own statistics from New South Wales Police that show that First Nations people are poorly treated by some aspects of New South Wales Police and poorly overrepresented in statistics when it comes to policing.
Thank you, Ms. Lee. We'll turn to questions from the government. Mr. Lawrence.
Chair, and thanks, Ms. Lee, for your evidence. It's really helpful. I just want to ask you about Section 31 of LEPRA, which provides in part of it that when a police officer is considering undertaking a strip search, they need to consider the seriousness and urgency of the circumstances and form the view that they make it necessary to search. In your experience, does that part of the section get any use in terms of searching for possession of small quantities of drugs? And what I mean is, do you know of cases, or is it common for police to be considering a search but then form the view that because it only pertains to a small quantity, say, of cannabis, that part of the section is not made out, and then they decline to undertake the strip search? Is that common?
Yeah, thank you. I mean, what the figures suggest, because there's around 3,000 strip searches just last year alone, that says to me that police are not turning their mind to the threshold of serious and urgent. But if the basis of the search is because of minor drug possession, my submission is that police are not turning their mind and not meeting that legal threshold of serious and urgent. The first step would be for them to first turn their mind to whether even a general search is necessary. So just because, for example, a drug dog indicates is not a reason to conduct a search. That's in the New South Wales police SOPs around drug dogs. It does not give police a reason to search. It only gives police a reason to question and then form reasonable suspicion whether a general search should be conducted. So even if a general search is conducted and nothing is found, that does not then give police the legal threshold to then conduct a strip search. So a strip search has a very high legal threshold, and if you're going straight from a drug dog indication to a strip search, then that says to me that you have not turned your mind to the legal threshold of serious and urgent.
So are you aware of any internal police guidelines or like documents that directs police as to how to consider this question of the seriousness and urgency of the circumstances, and in particular, any guidelines or like internal documents that say to police, for example, you must consider what it is that is in your mind that the person might be in possession of, and if it's, say, a small quantity of cannabis, then you might form the view that, quote, the seriousness and urgency of the circumstances, end quote, do not make it necessary.
No, the current guidelines or the standard operating procedures are called the Personal Search Manual by New South Wales Police. It does not set out a framework for what you have just said. What we really want is for LEPRA to make it clear that serious and urgent does not actually, that minor drug possession does not meet that legal threshold of serious and urgent, for the legislation to give that example and to provide better guidance to police about that threshold.
Yeah. So Section 31 in that respect would seem to be a legislative indication to police that they should be considering all the circumstances, including this potential offence that they have in mind. But would you agree that it's not an efficacious way to give that sort of direction or indication to police by putting it in a subsection in a somewhat coded way where it talks about seriousness and urgency, and that to be efficacious, it needs to be clearer, that sort of direction?
It does need to be clearer, yes. It needs to have the police need to have a rigorous understanding of what serious and urgent means. Otherwise, we'll see that this many strip searches occurring, which has started around 5,500 in 2019. And that if there is just suspicion of minor drug possession, then that in itself tells me that they cannot conduct a strip search because it does not meet that high legal threshold of serious and urgent.
Yeah.
So
Ms.
once
Lee-
they form that suspicion, they cannot conduct a strip search.
Can I just jump in? Are there any cases that have tested that? Have you or others taken cases that have tested that threshold of serious and urgent?
There's not many cases that have gone to hearing. Most strip search cases settle. There is a case called Talia, where a man was strip searched. It was though in police custody. He was strip searched on the basis of suspicion of minor drug possession, but the court found that police actually didn't even meet that threshold of reasonable suspicion. He was awarded damages in the civil court of $110,000. And there's only one other case I can't remember off the top of my head, but yes, there's not many cases that have come before the court.
Could you take that other case on notice? And send
Sure,
us-
thank you.
Sure, I've just got
Provide that.
one more question.
Yeah,
if
no,
that's
you've
all right.
got 10 minutes.
Oh, do I? Okay, good. So your submission says that 91% of all recorded reasons for conducting a strip search are the possession of drugs, or 91% of strip searches are about the possession of drugs. Yeah.
Yes, minor drugs. Like
So how
minor
many
possession.
of those cases, and I appreciate you won't be able to be specific, but how many of those cases do you think would fall into a category where searching for the possession of drugs is the ostensible reason for the search, but in fact the search is occurring as part of either a motivation in relation to some other offence, or searching for drugs as part of proactive policing because the person's on a target list. So there's a sort of collateral reason for the search, in fact.
Look, it's hard to tell, but what we do know through the statistics from the University of New South Wales Vicky Centis report is that only under around 9%, 10% of strip searches end up in a conviction of supply, and even less end up in a conviction for use of a weapon. So that says to me that strip searches are being used, one, unlawfully, but also as proactive and also as an aggressive way of policing. That strip searches are very traumatic, and for me, taking instructions from young people, it feels like strip searches are being used as a means by police to say, well, don't do this again because this is what will happen. It's a very aggressive form of policing, and it leaves a long-lasting impact. And I would submit that the majority of strip searches done by police are unlawful, and they have not met the legal threshold to conduct them.
So if you assume that a lot of strip searches are being undertaken as part of proactive policing, so for example, a person's on a target list, not because police are concerned that they'll be in possession of minor quantities of drugs, but police are concerned that they'll do other offending, and they're using drug laws in effect as part of proactive policing. Is that legitimate or not legitimate? Like, is that an important part of the police armoury of powers? Is that a legitimate way to interrupt offending, or is it not a legitimate thing to be using drug laws as a pretext for some other objective?
Well, one, it's unlawful, not legitimate, and harmful. What we found through the coroner's court inquest into deaths at music festivals is that strip searching and drug dogs are having a harmful impact on young people's health and the possibility of them dying at a festival, because what young people do is that they know that police are going to be at these festivals, and they preload those who are taking drugs. So instead of taking one drug at a time, they may take 4 or 3 drugs or pills before going into the festival. They then go into a festival that it's hot, they don't drink water, and if they do feel unwell, they won't ask for help because they're too scared that they're going to get into trouble. So this whole atmosphere or context actually harms young people and causes an atmosphere where it may lead to death, mostly because they won't ask for help. And what we want from New South Wales policing is where anyone can ask for help, not because they feel that they're going to get into trouble, but they feel that they're going to get some assistance, particularly if they're having a bad drug experience.
Ms. Lee, thank you very much for your evidence. Unfortunately, I was running from the old schedule, so I thought we were going to 10:15, but apparently we're only going to 10 o'clock, so we've run 8 minutes over. I apologise to everyone for that. But thank you very much for your evidence today. We very much appreciate you taking the time to appear. We also thank you for your submission and the work you do in the community. So thank you again. The Secretariat will be in contact regarding that matter you took on notice. Everyone else, unfortunately, I've cooked the clock and you've only got 7 minutes for morning tea. So apologies for that. But Before we get underway, I just get you to state your name and position title and swear either the oath or affirmation, please.
Robert May, Chair of Addiction Psychiatry Branch of New South Wales College of Psychiatrists. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Dr. May. If I could just get you to bring your microphone a little bit closer to there so that Hansard can record everything you say for all time. So, Dr. May, would you like to make a short introductory statement?
Mm-hmm.
Thank you very much.
Yep. So on behalf of the College of Psychiatrists and the New South Wales branch,
Order, colleagues.
we welcome the invitation to make a submission on this proposed legislation. From the perspective of psychiatrists who are concerned with mental illness and the subsection of addiction, this proposed bill is of interest to us. First of all, from the potential effects of cannabis in the community and its effect on mental illness, but as well as the regulatory framework and the way in which some members of the community are targeted by the criminalisation of cannabis. So we would like to first and foremost say that we are in support of decriminalisation of cannabis, from the point of view that it does negatively affect people in our communities which are already disadvantaged in terms of Aboriginal and Torres Strait Islanders, young people and people located in rural and remote communities. And from our concern of increase in the incidence of mental illness, we have not found there to be any increased harms associated with psychosis or other mental disorders as found in evidence from the United States, as well as what we've observed in the ACT. In other matters related to the proposed bill, we do have concerns with some of the regulatory framework in relation to the therapeutic prescribed cannabis, and that we have seen that there's been an increase or flooding amount of cannabis into patient populations with existing mental illness.
Thank you, Dr. May. Ms. Fairman, do you have questions?
Yeah, I did just want to, your last statement there, so you're talking about medicinal cannabis that is kind of readily available via a phone call or whatever, seems to be very easy to be obtained. When you're saying with existing mental illness, could you just expand a little bit on that?
So there has been a rapid uptake in prescribed cannabis, and like you're mentioning, a lot of it is very easily accessible, sometimes without even having to see a doctor face to face. And from our perspective of treating patients with underlying severe mental illness, such as mood disorders or schizophreniform disorders, that cannabis has been seen to exacerbate and cause relapse in people with those conditions.
Yeah, okay, so I want to kind of tie that in within your submission. You talk about the ACT framework, which has legalised cannabis, and that when that happened, obviously there was a significant reduction in cannabis offence notices obviously being issued, but significantly as well, and this is a key part of any legal framework, is the education and information and transparency around, therefore, the taking of the or using a drug itself. And you say that the ACT Health did a public health campaign, and that the ACT Health data shows no increases in hospital presentation since the laws passed. So you support a legal framework, or is this just noting what's happened in the ACT as reasonably beneficial because, my question is, I think you're noting that the increases in medicinal cannabis, the increases in people with mental health issues. However, on the flip side, there's evidence in terms of a legal framework of increased information, increased health. So, increased information from ACT Health about public health warnings. Are you saying there's not enough public health warnings in place now under the existing medicinal cannabis framework?
I would say that there could be more, and that there isn't a good level of knowledge, I think, by people who are accessing medicinal cannabis, and that those who have found ways of acquiring it often are unaware of the harms.
Yeah, so with it's also in here about, and in the US where cannabis has been legalised, you've got your submission as well states that some research that says there's no statistically significant difference in the rates of psychosis-related diagnoses or prescribed antipsychotics in states with medical or recreational cannabis policies compared with states with no such policy. And is this because, from your point of view, is it because with a legal framework people get access to that information, there's more people are able to talk about the impacts of cannabis and psychosis much more openly and transparently? Otherwise, wouldn't you think that there would be more psychosis with people being able to access cannabis more? How come there isn't?
Yeah, so I think we've just got to distinguish between the two different populations that are using cannabis. So the first, I think the one that we're talking about mainly here is people that use cannabis recreationally, and having a framework to decriminalise cannabis we believe would be helpful, because we see the criminalisation of cannabis as a harm in itself, because once someone is convicted, then that has further consequences on their life. The second population we're discussing is people who are prescribed cannabis for a believed indication for a medical illness. So it is true. So in the submission that we have outlined is there hasn't been statistical increases in psychosis or other mental health related conditions at a broad population level. However, from the point of view from the College of Psychiatrists, we are responsible for overseeing the healthcare of people who are very vulnerable in a smaller subsection of the population who are vulnerable to having exacerbations of underlying mental illness.
And sorry, can I just jump in there?
Yeah.
That was your assessment when you talked about broad populations. You were talking about in the US, in jurisdictions that have moved to a broad legalisation medicinal regime. There hadn't been a statistical uptick in presentations of psychosis or other disorders.
No, there hasn't.
Just to be clear as well, I think it's more than just a medicinal regime. It's those states as well, isn't it, with where cannabis has been legalised for recreation. And so the importance of, in terms of any regulatory framework, the fact that allows for public health messages, information, people to share, speak with their doctor, their GP about cannabis use because it's legal. Do you think that is significant? And that's part of, obviously, an important part of any regulation is the fact that that information can then be widely shared.
Yeah, so education, I think, is extremely important in these situations. And, in terms of overall policy and harm minimisation, people who are accessing any form of recreational substance, the more information available to them would better guide the decisions. And the education that was received in the ACT, we believe, was helpful to their decision making as a state and as individual users of cannabis.
Thank you, Dr. May. Your submission calls for stricter regulations on medicinal cannabis prescriptions. You've just alluded to the fact that some people may be even being prescribed medicinal cannabis without seeing a doctor face to face. What changes do you suggest, and what evidence shows that the current regulations may be inadequate?
So the evidence that we see, although I can't refer to any documents, is something that I see and my colleagues see day to day in clinical practice. There's also been safe scripts, if anyone's aware of that, but it's a New South Wales real-time drug monitoring system. And the amount of patients that we see who have been prescribed medicinal cannabis is very high, and often the prescribers aren't located near where they live. Often they are located in other states such as Queensland, and the access to these products is very easy, and because of that, it's very common. So, as I was alluding to before, there are patients who are very vulnerable to having prescribed cannabis, and without any further regulation, they remain vulnerable to exacerbation of illness. So, some, I guess, practical improvements that could be made is that if patients are to be prescribed cannabis, they have to attend to see their doctor face to face. If patients have history of severe mental illness, such as requiring inpatient admissions to hospital, then they should be assessed by a psychiatrist prior to prescription. Or if patients also are disclose or show that they have substance use disorders, and they should be referred to addiction treatment centres.
Thank you. You mention in your submission, you talk about actually cannabis use disorders and gaps in the current pathways for people who are suffering from that. Can you give some examples of some current gaps in that regime and what you think should be done to address it?
So, cannabis is the third most used substance in our population in Australia, and cannabis use disorder does develop in approximately 10% of people who are regular users. Unfortunately, the knowledge of cannabis use disorder is quite low in the population, and often people who have the disorder might not even know they do or where to go to seek treatment. There are limited available drug and alcohol centres that actually offer tailored intervention for cannabis use disorder. A lot of our treatments available target, I guess, drugs that seem to be more problematic, such as crystal methamphetamine, alcohol, or other substances. So if there were more readily available outpatient counselling services to people who use cannabis, such as cannabis clinics, which were more prevalent in the last 10 to 15 years, I believe some of them are closed now, then that would offer a new pathway forward for those who use cannabis identified as a problem and would like to seek treatment.
Thank you. Anecdotally, I've heard that quite a large number of the people who are using illicit cannabis are actually self-medicating for a range of ailments such as pain, but also for issues like PTSD, anxiety, depression, these types of things. Is that your belief as well, that a significant proportion of the illicit market of cannabis is actually a sort of de facto medicinal market?
I would have to start by saying that research of using cannabis for the treatment of mental health disorders is in a very preliminary stage. The opinion of the College of Psychiatrists is that cannabis is associated with mental illness in a more causative relationship than it is for treatment. So we know that there is a very strong relationship between cannabis and depression, particularly in adolescence and young adulthood. And like I've mentioned before, cannabis can certainly exacerbate underlying mood and psychotic disorders. We as a college are hesitant to support cannabis as a use of treatment for mental disorders, particularly as currently there's no information in support of that. I do acknowledge that in other disorders such as chronic pain, there has been evidence to suggest that as an emerging treatment it might be helpful, but to frame cannabis use as treating underlying mental illness, it would not be consistent with our views as a college.
But I wasn't really saying, I wasn't asking you to say whether or not, in terms to comment on the efficacy of the cannabis use, but do you have a view on why people are actually using it, that they may be self-medicating, whether or not it's working or not? Is that your belief, or what?
Yeah, so I think that there would be a percentage of people who experience symptoms of one kind or another, may it be extreme emotions, anxiety, other forms of mental distress, and using cannabis in some way might blunt those feelings or those thoughts. However, similar to other substances, for example, alcohol, it would probably work in the short term, but over the long term, it's not a effective treatment. Although, as I guess what you're saying, underlying there are probably emotional issues that person might make them more predisposed to using cannabis.
Thank you. You propose in your submission, a public health campaign to discuss the potential harms of cannabis. Could you expand on that? What do you see the significant harms of cannabis being, and how best would they be conveyed to the population?
Yeah. So, as I've previously mentioned, cannabis is an addictive substance. Up to 10% of people who use it regularly are at risk of developing dependence. And once someone is dependent, the risk of harms increase. There is associations between cannabis and depression, cannabis and anxiety, as well as some concerns related motivation and cognition for people who use cannabis chronically. In terms of a public health campaign to better educate people about these, particularly in a setting where they would have increased access, I would probably have to defer to my public health colleagues in what would be the best way of delivering that messaging to the populations who are most at risk.
Thank you. In your submission, you talk about attracting more professionals to the drug and alcohol treatment workforce. You suggest that's one of your suggested recommendations. What specifically would the college like to see to bring that to bear?
Yeah, so unfortunately, the workforce in addiction centres is burnt out and experiencing high volumes of vacancies. So in order to attract more qualified staff, we'd have to have a difference in terms of messaging, in terms of why people would want to work in the drug and alcohol sector. But another ongoing issue within the health sector is remuneration for our services, which has not been increased, at least in line with inflation for some time. So, yeah, the workforce remains very burnt out and seems to be decreasing over time, and that is particularly in outpatient settings where people would seek treatment for cannabis use disorder.
Thank you. You talk about and advocate for harm reduction services for Aboriginal and Torres Strait Islander communities. What specific interventions do you propose, and how will they ensure these communities receive the same standard of care as non-Indigenous communities?
The Aboriginal and Torres Strait Islander population is unfortunately at increased risk of harm. I think, at least from our submission, decriminalisation would be a great first step forward, particularly as the discretionary powers used by police is very unfavourable towards that population. For Aboriginal and Torres Strait Islander people to benefit the most from treatment, delivering it in a culturally competent way is essential, and as such, the employment of people from within the Aboriginal and Torres Strait communities has been shown to be very helpful. The adoption of the peer workforce, particularly Aboriginal and Torres Strait Islander people co-located within addiction services, has been incredibly helpful, as well as allowing access to treatment locally, so to regional, remote and rural areas, if the staffing was available, would be very helpful.
Thank you. Questions from the opposition?
Thanks, Chair. I've got a few, and thank you for your submission and evidence, Doctor. The first question I had was, you note in the submission that in jurisdictions that have legalised that there hasn't been a reported increase in cannabis-related harms, and I'm wondering, is that because there has been no increase in the use of cannabis, or is it because the measures that accompany legalisation have decreased some harms which have offset an overall increase in use?
Could you just repeat the first part of that question? Sorry.
Yeah, sure. So the submission from the college reports that in jurisdictions that have legalised that there hasn't been an increase in cannabis-related harms, such as psychosis and the like. And I'm wondering whether, is that because in those jurisdictions there's been no increase in the use in cannabis, or is it because, notwithstanding an increase, some of the measures that accompany legalisation have offset the harm or reduced the harm?
I mean, I don't know what the answer to that question is. I would assume that with legalisation of cannabis, people would use more, if not stay the same. And as for the effectiveness of a public health campaign regarding the harms of cannabis, it would be difficult to quantify exactly what part of or which of those factors would be resulting in that outcome.
Sure. In terms of mental health, what are the main negative effects of criminalisation and the lack of a legalised market for cannabis?
So people that use drugs, as well as those with mental illness, already belong to a highly stigmatised population, often struggling with socioeconomic disadvantage. So criminalisation of using cannabis, although has some harms compared to other substances, not as much, further stigmatises this population and puts them at risk of remaining in socioeconomic disadvantaged areas and limiting their capacity to, say, gain employment or rejoining the workforce, and further entrenches their situation.
Yeah. Is there issues in terms of, in a market where cannabis is illicit, are people using more harmful cannabis than they might be in a legalised market?
That's possible. Whenever there's an illegal market and people are buying any substance, obviously it's unregulated. We don't know what the percentage of THC or other cannabinoids are, and patients will tell you, whatever they buy could vary, quite a lot from one day to the next. So there is an increased risk of harm with a unregulated supply.
So there's types of cannabis that are available in the illicit market that wouldn't be approved for sale in a regulated market, is that what you're saying?
Yes, so we don't know what the percentages of the cannabinoids are within these products, so it's entirely possible that they wouldn't be appropriate to use yet.
Yeah. I think one of the main concerns in the community about decriminalisation and legalisation of cannabis is the belief in the community or segments of it that there's a link between psychotic illnesses like schizophrenia and the use of cannabis. So I was wondering if you could firstly just explain what is the link between psychotic illnesses and cannabis, if any?
There is a relationship with the incidence of schizophrenia and cannabis, which is related to age of onset of first cannabis dependence. So for individuals who smoke cannabis daily at age 15 or below, they are at a increased risk of schizophrenia to the order of double. However, schizophrenia is a low prevalence disorder affecting less than 1% of the community, and in the population who would be smoking cannabis age 15 or below daily is extremely small already. So it is a very small increase to an already small number.
Yeah. So could you just explain in layperson terms why it is that the college, notwithstanding that link between cannabis use and psychotic illness, why it is that the college supports decriminalisation and or legalisation?
So for the reasons that I've outlined already, it is an assessment of risks and harms, and the college has come to their position based upon the population of people who we represent, that criminalisation causes more harm to people living with mental illness than if it were decriminalised. So, as I mentioned, due to socioeconomic factors and vulnerability, stigmatisation, marginalisation, decriminalisation would allow at least those people with cannabis to be less targeted by the current law enforcement.
And in terms of the vulnerable cohort, so the people who, if they have daily use prior to that age of 15, there's an increased chance of the development of psychosis. Are they any more likely, do you think, to access cannabis under a regulated system involving decriminalisation and or legalisation?
I'm not sure if they would be at any increased risk or at any increased way of accessing cannabis. I would think that people of that population, access to substances often isn't, the legal framework often isn't a barrier, particularly independent use. So I would think that their substance use would probably be unchanged. However, at least there wouldn't be further consequences in the law or the legal system up to a person who's already quite disadvantaged.
So how reliable is that research as a pointer towards cannabis being the cause of psychosis-related illness? So, for example, is it the case that it could be explained by people with that predisposition being more likely to seek out cannabis use? Is it clear on that research that cannabis is causative, or is there some complexity there?
It's clearly a difficult relationship to characterise clearly. However, in that's why that population is so defined. So it is a causative phenomenon that has been shown in literature for that population. However, above the ages of 15, obviously cannabis use is more common, and so is psychosis and schizophrenia. So the only causative relationship has been able to be found in that particular population of those 15 years and below.
Oh, okay, so it is causative. So it's not explained by them being more likely to seek it out, on your understanding of the research?
So, I mean, that would be another theory and also a confounder to the research body, but that's that's what the college and what the literature supports.
So what would be the objectives of the public health campaign that your submission speaks of in a legalised context? What would the objective be of a public health campaign? Would it be to overall reduce use, or to raise awareness of psychosis issues, or to raise awareness of more like anxiety and depression as being possible products? What would be the objective of it?
So all of those things, I think first and foremost, public health campaign around any addictive substance would be to encourage people to use less or use more safely or not use at all if possible. Followed by, if people did choose to use, how to use it in more safe circumstances in terms of their mental health or physical health. And also, if people did develop symptoms, knowing what symptoms are related to cannabis use and how to seek help would be helpful.
Yeah. So do you see any policy rationale under the existing law for treating the giving of cannabis to a friend, not for financial benefit, as supply rather than possession? So the reason I ask that question is because under federal law, it's only drug dealing or trafficking if you're doing it for money. Whereas in New South Wales, under our state law, you commit the offence of supply, which is the offence that applies to drug dealing, even if you give a small quantity of cannabis to a friend, for example. So you might be smoking marijuana together and you give them a small quantity. What do you think about that as a policy issue? You got any thoughts on that?
As I've alluded to, people with substance use disorder, who are people who I see, legal barriers, financial barriers, often are not reasons why people would choose not to do the substance, given that it's an entrenched pattern of behaviour. So I'm not really seeing the benefit of someone being charged with dealing in that situation, as it's likely that the person who receives the cannabis anyway would have got it from some other place anyway.
Yeah. So you said that cannabis is addictive, and there's sometimes, I think, a bit of dispute in the community about that proposition. Some people think it is, some people think it isn't, and people, I think, would think about something like methamphetamine or heroin as being more truly addictive. Are you able to explain on a medical level why it is that cannabis is considered to be addictive?
Yep, so like any of the addictive substances that you've mentioned, so daily use of a psychoactive substance which can reformulate the pleasure reward system in the brain becomes addictive. So even, for example, nicotine is addictive, and after people stop smoking cigarettes, they can have a withdrawal syndrome. So cannabis is exactly the same in that respect. So daily smoking of THC, which is the active or psychoactive component, causes dependence, which we can see in the DSM-5, for example. They've got cannabis withdrawal as a discrete disorder, and those people who seek help sometimes require, say, inpatient detoxification, where they're admitted for up to 5 days with a very recognisable psychiatric syndrome of cannabis withdrawal. So, agitation, insomnia, those sorts of things, yeah.
So do you think medicinal cannabis is being used as a device to achieve a form of decriminalisation, a de facto legalisation? And if you think so, is there any issue with that in terms of the medical profession, the role and purpose of the medical profession? Like, are we doing something that undermines the medical profession in some way, whereas we should just maybe engage with the real issue and decriminalise or legalise? Have you got any thoughts on that?
I do think that, at least from the perspective of psychiatrists, it does undermine our research and our work. And patients that we see will often say, I'm taking this because it's my medicine or it's prescribed to me, when we are often much more concerned about the harms. And, had we prescribed it ourselves, or were we, had we been in the process of the prescription with a, regular doctor, or, doctor that they've had a text message with, we would have advocated strongly for the cannabis to not be prescribed. So I do have concerns with the way that medicinal cannabis has been granted access to patients in the community. And my belief is that many patients who are prescribed medicinal cannabis the harms are likely outweighing the gains.
So just lastly, there's a bit of a vexed issue that's canvassed in the submissions. I'm not sure if it's actually in the college's submission, but about driving and cannabis. And it's often said, for example, there should be a medicinal cannabis use exemption to the drive illicit offence. And it's also said that the drive illicit offence doesn't have a link in it between impairment and driving. And it's said, for instance, there should be like a drink driving type regime attached to that. Are you on top of those issues? Yep.
Yeah, so I think that is it's quite a reasonable and common sense approach. As with, say, alcohol, we've got an accepted range of what is appropriate to be allowed to drive and what isn't. And in the space of cannabis, medicinal or otherwise, we don't have a way of measuring what is safe and what is not safe when people are driving.
Yeah, that's what I wanted to ask you about. So, I mean, there's sort of two things to my mind. One is there a test that can measure impairment? And then the second issue is, if there is such a test, are people able to reasonably adapt their behaviour to the test, i.e. work out how affected they're likely to be in the circumstances and then make a decision about driving. For example, we sort of know with alcohol that, 1 or 2 drinks in the first hour, 1 every hour after that, or something like that is the formulation. Are we able to realistically, in a responsible way, move to some sort of different regime to govern driving after the use of cannabis in the context of those two issues, or are they insurmountable at the moment, do you think?
I'm not aware of any research currently that has characterised that, or any diagnostic test or something that's able to delineate what is safe and what is not safe. It's definitely been spoken about, but I can't say that I'm aware of any research that's been currently conducted.
Yeah, okay, sure. Thanks, Jen.
Dr. May, you said in your previous answer that, and I don't mean to verbal you, but that the efficacy of cannabis, therapeutic benefit for some like disorders like anxiety and other disorders, anxiety, depression, is contested at the very least. What's your view, though, on cannabis as an alternative, and an alternative with less harms when compared to other antidepressants and opiates that can be, addictive as well? Does the college have a view on that, on whether or not the medicinal cannabis or the cannabis may well be less harmful in terms of ongoing psychological effects or addiction?
So I think our standard treatments for high prevalence psychiatric conditions such as anxiety and depression have been through numerous randomized control trials over the past 70 years. So we have a firm evidence base of what works in anxiety and depression with our current treatments compared to those that don't. The medications that are used for high prevalence conditions such as anxiety, depression and antidepressant medications are shown to be low risk in terms of, one, they're actually not addictive. Sometimes it can be what we call discontinuation, but it's not a sort of a substance use disorder in terms of someone feels as though they need to take their medication, otherwise they don't feel normal. And those drugs often have a delayed response anyway, so it can take several weeks for people to experience a benefit from that. And usually when they do stop the medication, the side effects are mild or insignificant. For, I think you did mention opiates, so opiates we only really use in opiate agonist treatment for replacement for, say, heroin and other things.
But what if someone's taking opiates because they're in pain, and that pain causes them to be depressed? And so...
Oh, I see what you're saying, yep. So Yeah. So I mean, it's probably that question would be better addressed to, say, a paying physician. However, the current treatment of chronic pain is for de-prescribing of opioid medications, and it's more recognised now that biomedical treatments such as those using opiate medication or other substance dependence forming medications is unhelpful, and that the biomedical model of chronic pain has been challenged in the last 5 to 10 years. So I think I see what you're saying with that question. Maybe cannabis would be less harmful than, say, opiate medication. Which may be true. I know that there is some evidence in that area. However, the overarching perspective is that for chronic pain, medications are not particularly helpful and generally cause more harm.
Okay, thank you. Colleagues, do you have any more questions? Dr. Kane, are you still there? No. All right. Well, thank you, Dr. May, for your evidence today. We very much appreciate it. And to the college for the submission you made and for your work you do in the community. So thank you very much
Thank you.
for attending
you.
today.
Thanks
We
very
very much appreciate it.
Thank you.
You, Dr. Liu, for your attendance today at today's hearing into the regulatory framework for cannabis in New South Wales. Before we begin, could you please state your name and position title and swear either the oath or affirmation, please?
Yep, so my name is Dr. Thomas Liu. I'm a general practitioner. And then just swear on the oath.
Yeah, oath or affirmation, whichever
Affirmation.
you...
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you, Dr. Liu. Do you have any, like an opening address or some introductory comments you'd like to make?
Yeah, I do. I'm here today on behalf of the Royal Australian College of General Practitioners. I would like to thank the committee for the opportunity to give evidence at this hearing. The RACGP is Australia's largest professional general practice organisation, representing over 40,000 members working in or towards a specialty career in general practice. The RACGP and ACT faculty actively supports and advocates for GPs working throughout the state. I'm a member of the RACGP specific interest groups on addiction medicine, psychological medicine, neurodiversity and geriatrics. I'm also a member of the NSW and ACT faculty. I'm here to represent the views of the RACGP. The RACGP is a strong advocate for evidence-based medicine and does not currently recommend nor encourage the use of medicinal cannabis. However, it does recognise as specialists, general practitioners may offer to prescribe medicinal cannabis products to a limited number of patients with specific conditions in consultation with those patients and their care teams in alignment with the most up-to-date evidence. This inquiry is an opportunity to illustrate the state of play for accessing medicinal cannabis products, as well as the potential for legal decriminalization posed by the current regulatory framework. I look forward to working with the committee on this matter.
Thank you, Dr. Liu. Some questions from Ms. Fairman?
Sorry, 2 secs. Can you go to somebody else?
Okay. Mr. You're good. Well, thank you, Dr. Liu. Can you elaborate on the evidence base that informed your submission, particularly regarding the relative risks and benefits of cannabis use?
I guess the submission is based on the most current up-to-date literature which I think many people have sort of referred to. I think currently the literature is not well defined on the role of medicinal cannabis, although it's most well researched for chronic pain. The research currently is limited by studies that are of low to moderate quality, and that's because of their low sample size, short follow-up periods, perhaps their study design as well. I think also there is inconsistencies regarding studies in terms of the type and route of administration of cannabis as well. There is some other evidence within the literature currently which looks at the use of cannabis for some other indications, such as severe or persistent muscle spasms, post-traumatic stress disorder, seizure disorders, cachexia wasting, but these are currently being looked into.
So is it the college's position that despite the fact that medicinal cannabis is been legalised over a large swathe of, the world, including Germany, United States, United Kingdom, Australia, that there's very little evidence that it has any therapeutic benefit for pain and other conditions, and that any evidence that there is based on faulty or flawed research?
I wouldn't say that. I think the evidence base for medicinal cannabis medicine is not strong compared to some of the more traditional forms of therapies that we have. For example, the management of hypertension and hypercholesterolemia. They're very well defined within the literature. I think certainly the current evidence base, in comparison to those other forms of more mainstream therapies, is not present. But that is not to say that the current evidence isn't supportive of general practitioners who are specialists to discuss medicinal cannabis with their patients with very specific conditions based on their understanding of the most up-to-date evidence.
Pain's not a very specific condition, and it's the number one reason that people are being prescribed medicinal cannabis in Australia. Do you think that that's a mistake, that there's not an evidence base that it's actually having a positive impact on people's condition?
I wouldn't say again that there's not a evidence base. I would say that the evidence base at the moment is of mild to moderate quality, and I think that is sufficient for some general practitioners in some specific patient cases to prescribe for patients with chronic pain, in the case of, for example, chronic low back pain. But I would also suggest that medicinal cannabis is not a panacea, and that for many of these more complex conditions, for example, chronic low back pain that is quite debilitating, where other forms of therapy have not been effective, that medicinal cannabis can play a role, but it is done within a multidisciplinary, holistic and integrated framework which general practitioners are able to provide.
Thank you,
Ms. Fenn.
Chair. Thank you. One of the criticisms, in fact, sometimes of general practitioners is that they don't provide a holistic framework, though. They're kind of, in some ways, quite quick to prescribe, standard prescription drugs. And you're thinking just in terms of lower back pain, though, that exactly in terms of exercise, like that is one of the things for lower back pain. Do you think that, are you seeing any reduction in people seeking standard prescription drugs for chronic pain or standard treatments for chronic pain because of the increase in medicinal cannabis prescriptions and medicinal cannabis use in the state? Have you noticed any difference there?
So I guess first to the comment that there is a perception that general practitioners offer scripts for most things. I would disagree with that wholeheartedly. As part of the RACGP, we strongly advocate for multidisciplinary care, holistic and integrated care that general practice practitioners are most suited to be providing. So I think that's very sort of evident from the college teachings and very evident from the training of the next generation of future general practitioners, especially within the curriculum. So I acknowledge that perception, but I would strongly disagree with it, and I think most general practitioners would disagree with that perception of how general practice is undertaken. In terms of the question, I think your second question is, has there been a reduction in other prescribed medications due to medicinal cannabis? I think it's difficult to say because there isn't really currently, I'm not aware of holistic research on that matter. I think certainly for some patients, anecdotally, they might prefer medicinal cannabis and use it in replacement of another medication. For others, it is an addition. I think the data is just currently not there at the moment to be able to give a firm answer on it.
Which points to potentially the need for more research in this space, doesn't it? Particularly probably at a state and federal level here. More research around the use, what people are using it for, what they're potentially substituting medicinal cannabis for in terms of other more standard prescription drugs.
Yes, I think there is definitely a role for looking at that question in particular. I think there is some data though at the moment just on what cannabis is used for, medicinal cannabis is used for.
I wanted to turn to your submission where you talk about our current roadside drug testing laws, and your submission makes the point that it calls the current regulation unreasoned because the distinctions made between medicinal cannabis and other potentially sedating medicines such as opioids, and I think your submission's making the point that that's potentially discriminatory. Would you care to expand on that?
So I guess there is some actually good evidence about medicinal cannabis in driving. There is a paper published within the Australian Journal of General Practice back in 2021 which summarises the state of play at the moment. Looking at crash risk and crash culpability estimates, medicinal cannabis at the moment has an increased crash risk of maybe 1.1 to 1.4 times compared to not being on anything. This is on a similar level in comparison to a blood alcohol level of 0.05. So there is an increased risk of crash, and that I think has been delineated within the Ausroad guidelines about the current state of medicinal cannabis usage. But at the same time, other substances such as benzodiazepines or opioids can also increase crash risk, and those are things that are not currently tested by the roadside. So I think there is some inconsistency there, and I think that could be what the submission is referring to.
What was the research that you were referring to? What was that again?
So this, unfortunately, I did not get to put this in the table, but this is a paper published by Akel et al. With Ian McGregor.
Yes, I know that.
Would you
Did it
be,
have the?
could we get that a copy?
Of course,
that?
yeah, definitely, yeah.
And do you have the research in front of you there in
I
terms
do.
of what so you mentioned benzo, for example, benzos. What was the increased crash risk for other pharmaceutical drugs?
Yeah, so for benzodiazepines, the increased risk estimate is 1.17 to 2.30.
So higher than medicinal cannabis?
Look, they're sort of actually within the normal confidence interval. The confidence interval overlaps, so I think it's really difficult to say whether benzodiazepines is more riskier than cannabis, because I think the data isn't super clear, and there's no head-to-head studies, so it's very hard to say. But I think there is increased risk of benzodiazepines and other opioids. And other prescription drugs, particularly if they are taken not as per the guidance of the medical practitioner, and if they are causing clinical symptoms such as sedation and confusion for the patient.
So is it the college's view that we should be testing for opiates if they're comparable to cannabis in terms of the impairment? Is the college's view that we should be testing at the roadside for opiate and benzodiazepine impairment? And if not, why not?
I think that's a difficult question to answer. I'm not sure if the college has a view. I will take that question on notice and get back to you.
Are you aware that there's currently an exemption? There's a medical defence in the Roads Act for opiates. I'd be interested in the college's view on the retention or not of that defence.
I'm not sure about that. That, and I can take it on notice. And
You take that on notice, it'd be appreciated. Mr. Ruddick.
Thanks for joining us, Dr. Lou. So I wasn't quite following you when you say that there is an increased risk of a car accident with medical marijuana, and you said a figure of 1.4. Are you saying there's like a 40% increase of having a crash?
Well, it's a range based on multiple different studies, and it's a range of 1.1, so maybe 10% more likely,
Right.
to 1.4 to 42% more likely. So
Okay, but
1.1 to 1.4 times more likely.
Would I be correct in assuming that would be within the 12 hours of consuming the medical marijuana, and they wouldn't be impaired after that period? Would that be accurate?
I think this particular paper, or this particular sort of guidance documentation or evidence summary doesn't delineate this, but my understanding of sort of the current research is that yes, that's the case. Yeah.
Well,
but it also depends on many other factors as well, I would think, whether the patient is on long-term medicinal cannabis or on cannabis, how it affects them personally, and also whether they are tolerant of their medications.
Okay, but I mean, as the chair just said, there is a carve-out for if somebody's driving and they've got an opioid in their system, but they have it prescribed, then it's not an offence. But there is no. But I understand if people consume medical marijuana, and they have a roadside test, it can show up for 30 days afterwards. Now, I think common sense tells us that people aren't going to be impaired after 12 hours. Maybe it's 24 hours. But surely a week or a month after consuming the medical cannabis, they're not driving impaired. However, if they do have a road test and it's showing that it's in their system, it's an automatic default. So is that something that the college would be keen at? Would they be supportive of the law being changed so that there would also be a carve-out for medical marijuana?
I think the current systems of detection for THC is very complex.
Yes.
Firstly, my understanding is that it's a saliva test, and I think within New South Wales you have to have 2 saliva tests and then a blood test. and the testing currently is random. Within the saliva test itself, I think what the evidence is currently is that THC is present within 4 to 6 hours of smoking or vaporizing or using the oil. So cannabis is not excreted via saliva as a majority excretion. So usually it's got to be present within saliva through use. So that actually excludes some forms of oral capsules or gummies. So if you consume oral capsules or gummies and it doesn't sort of mix with your saliva, I think the current suggestion from the literature is that it's not going to be detected via saliva testing. So once saliva
But
testing...
it would be detected by a blood test.
That's correct.
If there was an
yes.
accident.
But yes, correct, yeah. So I guess coming back to the question of, what the college position is, whether there's a carve-out for cannabis, I think, again, that's a really difficult question to answer. And I'm not sure if the college is in a role to give a recommendation in that regard. I think we are medical practitioners.
Yes, but I mean, you do support in your submission. You seem a little bit ambivalent about medical cannabis, but you do say, look, we accept that some of our members will be prescribing it. So that means some of the customers, some of the patients of your members will be getting caught under this quite a serious offence when they're completely not impaired, because it might have been 3 weeks earlier. So I mean, I would think that people are getting caught up, innocent people are getting caught up here. It feels to me like there is a fairly serious hole in the law, and the law has recognised it for opioids, but not for medical marijuana.
Thanks for your comment. I think it's difficult to know if a patient has had THC within the system using the current evidence, whether that is contributing to any impairment or any crash for that matter, or impairment based on the current evidence besides what I've already quoted.
Thank you.
Dr. Liu, how many people in Australia die from opioid overdoses each year that were prescribed to them by a GP?
I'm actually not very familiar with that figure, as it wasn't within sort of the terms of reference, so I didn't get to look it up, unfortunately.
How many people die from an overdose from medicinal cannabis? Just on the former question, could you take that on notice?
Sure, I can take it on notice.
That would be good. Are you aware of anyone that's ever died? If I told you it was higher than the road toll, that it's thousands a year, would you be surprised?
I would be, yeah. I think medicinal cannabis, the risk of overdose in itself is not high. I wouldn't know the particular figure.
What if I said it was 0? Would you accept that's probably the case?
I probably would accept that, although I think in the context of very complex patients with polysubstance misuse or interuse, cannabis can contribute, but I wouldn't be able to give you a definitive figure today.
And what's the number one reason people are prescribed opiates?
Well, I think, as the previous psychiatrist mentioned, we use it primarily in opioid treatment programs for people who are opioid dependent. I think there are people who do prescribe opioids for acute pain, and I think that is very evidence-based and very effective. And there is also a significant role for opioids in cancer pain. I think that is very well delineated.
But which of those would be the principal reason?
Probably acute pain, really, for people who present to hospital with lots of, fracture or perhaps a kidney stone. Opioids can be highly effective in mitigating their pain and suffering.
Thank you.
Thank you.
Mr. Lawrence.
Thanks, Doctor, and thank you for the submission from the college. My first question is, does the college have a view or a sense about the adverse health outcomes for Australians that is occasioned by the criminal regulation of cannabis? So I'm talking about the accumulation of any adverse health effect from the searching, the arresting, the incarceration, etc., etc.
I think for people who commit crimes in the context of substance use, I think for many of them, their substance use is the key problem that is causing the criminal activity. And I think there is currently a wide array of diversion programs which is aimed at tackling those things. So, for example, the cannabis cautioning scheme.
Yeah, so I was getting more at the adverse health effects as a consequence of the operation of the criminal justice system. So you might have a patient who presents who's been the subject of a strip search. You might find there's some trauma issue from that, or you might have a client who's been charged with cannabis possession and has to go to court and then suffers anxiety as a consequence of that, or they might lose employment and then you might see adverse health effects because of that. I was getting more at the accumulation of adverse health effects on Australians as a consequence of the penal regulation of cannabis, the criminal regulation of it.
Again, I wouldn't have any specific data to pinpoint any of the things you mentioned, although what you mentioned makes a lot of sense, and I think anecdotally is something that we do see, that the penal effects can have an effect on people's health and mental health.
Yeah.
Would you be able to take that on notice and come back to us if you have a considered view from the...
Sure, we
Thanks.
can take it on notice. Yeah.
Okay, that's great. On page 4, I think it is, of the submission from the college, page 4, it says that that the potential impact of medicinal cannabis on driving safety is mitigated in the context of clinical consultation. And then it goes on to suggest that patients being prescribed medicinal cannabis as part of their care can be advised against driving when feeling sedated, when changing dose, etc., etc. And I was just wondering, is that based on any research, or is that more of a common sense proposition, in the sense that if it's prescribed, there's that avenue for advice to be given that might mitigate against the road safety effects?
I'm not aware of any firm research. However, I think that is very clinically, in that sort of advice is present in most clinical guidelines and education for general practitioners. I think, it's common advice that general practitioners would give within the holistic, integrated, appointment. Being able to provide a lot of information for the patients. And I think once patients are aware of the risks associated with this, then they do take it on board generally.
Yeah, sure. So does the college have a view on decriminalisation of cannabis?
I'm not sure if the college has a view. I don't think the college at the moment has a view on decriminalisation of cannabis.
Yeah, I mean, I think I might have gleaned that from the submission, that there certainly doesn't seem to be a positive statement in favour of decriminalisation.
I think... I'm not sure. I'm aware that I think certain members definitely are, very supportive of decriminalisation, and I think there's a lot of evidence base, particularly from Portugal, to support decriminalisation. I think what you can see in Portugal is that it's not legalization, but it's certainly removing the penal punishments, as you said, and then pointing people who do need help to the right form of help. I think that would be something that we do support. Although I think it's just not being firmly discussed, really.
So assuming that there's not a positive, clear policy position in favour of decriminalisation that the college has arrived at, it's certainly not the case that the college has a positive view in favour of criminalisation, is it? It's more that you just haven't reached a view to the contrary, but you're not endorsing the status quo. Would that be fair to say?
I would, suggest that. Yeah, correct.
And is that the same in respect of legalisation? So the creation of a regulated cannabis market where one can purchase it legally, etc., etc.
I wouldn't think that the college at the moment has a view on that either, and probably purely because the evidence is really not out in that regard. And secondly, we probably haven't seen it as our view, as our role in maybe having a view on this at the moment.
Sure.
Yeah.
Chair, can I jump in on that?
Yeah,
I'm just curious whether the position of the RACGP is officially changed since it came out very strongly a couple of years ago in relation to the ICE inquiry, in relation to the ICE inquiry's recommendations, which are about removing the criminal sanctions for the personal use of drugs. The RACGP signed a joint statement with the AMA, with the Royal Australian and New Zealand College of Psychiatrists, which called on the government to stop delaying its response to the inquiry. And the President, I don't know whether the President is still Adjunct Professor Karen Price?
No, it's not. Yeah.
So has that changed, do you know?
Look, firstly, I wasn't sort of aware of that sort of declaration, and also I'm mainly going off our submission, which wasn't mentioning sort of decriminalisation. So, I wouldn't think that there's been a change. I probably just wasn't aware of it.
Right. I think some of the statements here are basically about ensuring that personal addiction issues are treated as health and social issues, not in the criminal justice sector. And I think I have heard statements in the past by your organisation to that effect. I'm just trying to just clarify whether something has significantly shifted in the past 2 years that
no,
we
I
should
don't
be aware
think so.
of.
Look, I would agree with that statement. I'm just not aware of, I wasn't aware of that formal sort of, declaration.
Okay.
Yeah.
Sorry.
Nothing further from
jumped
me.
in,
Sorry, I was talking.
Sorry.
Sorry.
Are you aware, Dr. Liu, that cannabis has, for medical purposes and for recreational purposes, has been legalised in California for 8 years?
I'm well aware of that, yes. It's present in Canada and quite a few states in the US.
Yes, including California, which is the United States' largest state, and that the Medical Board of California supports a whole range of prescribing practices for a whole range of conditions in California, and that has widespread support and is underpinned by like a large body of research in terms of its efficacy.
Am I aware of that?
Yeah.
I wasn't aware of that fact particularly. Definitely aware that it's very prevalent in Canada and US.
Could you respond to that? Like, why do you think the Californians, like the Medical Board of California, has taken a much more positive view of cannabis than, say, the college has?
Look, I firstly like to say that, I think the college does recognise that as specialist general practitioners, some of us are very happy and offer to prescribe medicinal cannabis products to a limited number of patients with specific conditions in alignment with the most up-to-date literature. So I think I don't think we have a very positive or even negative spin on this fact. I just think that the current evidence is mild to moderate, and so I think we do. There are general practitioners who do prescribe medicinal cannabis. And then in terms of the question about sort of what is the why sort of California, etc., I wouldn't be able to give you a good answer for that. It could be a lot of societal and cultural differences that are present and prevalent, which contribute, but that's probably outside of my scope of expertise.
Okay, thank you. What's the college's view on the current regime around telehealth when it comes to prescribing medicinal cannabis? Do you think it's as robust as it should be? And if there were reforms there, what do you think they should be?
Yeah, I'm actually not familiar with the current sort of college perspectives on telehealth. Again, I think it wasn't part of the statement of terms of reference, but
we heard from the College of Psychiatrists that in some instances face-to-face interactions with a health professional is preferred. Is that something that you would concur with?
Absolutely. I think that face-to-face visits are really important because as general practitioners we do need to examine the patient, and I think some of that is lost over telehealth. And I think definitely face-to-face can add a lot more to the consultation, especially for these complex patients, particularly in providing holistic and integrated care.
Thank you, Dr. Louis. Colleagues, do you have any other questions?
Yeah, I've got a question.
One more from Mr. Lawrence.
The question is, Doctor, do you think that the current scheme for medical cannabis prescriptions is inequitous in the sense that it's allowing certain, perhaps more advantaged people to legally obtain, possess and use cannabis, maybe for a mixture of reasons sometimes, whereas other less advantaged people are left with the illicit market and all of the consequences of that?
I think that's, again, a difficult question to answer. I guess at the moment, the cannabis prescriptions are done through a SASP or specialised access scheme, and also the authorised prescriber scheme. So currently, the authorised prescriber scheme, where sort of practitioners can get approval from the TGA to prescribe directly, has quite blown out. The model of prescribing at the moment seems to be that patients can go to specific cannabis clinics and also general practitioners. So there could be a cost associated with that, but at the same time, that cost is probably less or comparable to other specialist services. Then I guess comes the question of the medicines in itself. And again, that is a question of comparison. So compared to, say, more mainstream medications, such as antihypertensives, anti-cholesterols, cannabis medications are more expensive. And that is because the cannabis medications are not part of the PBS, where there's a subsidy for these medications. However, compared to illicit cannabis from the illicit sources, medicinal cannabis can be cheaper compared to illicit sources, or more expensive, because there is a wide array of different cannabis products within the market at varying price points.
Yeah.
So I think it is a game of comparison within this current model, in the sense that yes, medicinal cannabis is more expensive compared to PBS subsidized medications, and there can be a fee associated with seeing a medical practitioner, but the fee is probably less than seeing a specialist, non-GP specialist, I should say, but is probably more than a bulk billing doctor, obviously, would be. So I think then the question of the inequality of access lies within this model. I think then more vulnerable community groups who have less socioeconomic access will definitely not be able to access medicinal cannabis as much as people who have more wealth.
Yeah.
Yeah.
So irrespective of the purpose that you're seeking medicinal cannabis for, the more advantaged you are, the more likely you are to be able to access it and in fact access it. Would you agree with that?
I would agree with that, yeah.
And if you're someone who wants to access medicinal cannabis wholly or in part for what is in effect a recreational purpose, you're more likely to be able to do that the more advantaged you are. Would you agree with that?
Yeah, I would agree with that, yeah.
Sure, thank you. Thanks,
Thank
Jeff.
you, Mr. Lawrence. Any other questions, colleagues? No? Thank you. Well, thank you very much, Dr. Liu, for your attendance today and giving evidence on behalf of the college. We very much appreciate you taking the time, and also for the college making the submission. The Secretariat will be in contact in due course for some following up on some of the matters that were taken on notice. But once again, thank you very much. We deeply appreciate it. And good morning to you.
Thank you, everybody.
Thank you.
Morning, Mr. Waits.
Morning.
Before we begin, I'd just like to start by thanking you for your attendance this morning. We very much appreciate it. We also appreciate the submission made by the New South Wales Nurses and Midwives Association. Before we begin, if I could just get you to state your name and position title and swear either the oath or affirmation.
Yeah, thank you. My name is Michael Waits. I'm the Assistant General Secretary for the New South Wales Nurses and Midwives Association. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Do you have some remarks to make before we turn to questions?
Not at this stage. I'm happy to go straight to questions. Thank you.
Thank you, Mr. Waits. Well, I'll turn then to the crossbench. Ms. Fairman?
Yes, thank you, Mr. Waits, for appearing today and for your submission. So is it fair to say then that based on the evidence of your members that the current regulatory framework around cannabis in terms of technically kind of still criminalising people for personal use is not is not very beneficial to society?
Yeah, we, we agree with that direction. Our view is that with all drug use, whether that's alcohol or other drugs, that harm minimisation is the best approach. We're particularly concerned that when you take drug use down a criminal path, it creates potential for a cycle, but also creates a level of stigmatism for those people, which is not the way that you deal with any health issue. The best way that you deal with any health issue is being able to work with people in a caring and nurturing way, not in a punitive way. So we see drug addiction as a health issue, not a criminal issue.
Also, I think it's potentially important too, isn't it, that if at some stage in the future, if the New South Wales government did decide to move to a decriminalisation model, that more funding would need to go into health services, into ensuring that there were more staff, for example, for treatment places, more nurses in that way as well. I think we've seen in some areas, where Oregon particularly, with decriminalisation there, that there hasn't been the necessary input, the necessary investment into health services. Do you have anything to say about that?
The feedback from our members that work in drug and alcohol at the moment is that it is under-resourced and underfunded, particularly in areas where the use of illegal drugs and alcohol is high. So, of course, we would welcome more investment in that, in particular making sure that we have safe spaces within our emergency departments for the treatment of people who are experiencing high levels of being affected by alcohol and other drugs. I think I would have to take on notice the question about the certainly there's a long proud history of changes to the way we deal with matters, envisaging that the health system will be able to cope without the health system getting the subsequent resources. So that's always mindful. I'm only aware of one study that talked about the rate of use in the ACT following decriminalisation, and there was no significant increases, is my understanding of that report. So would we expect to see higher levels of activity in our emergency departments as a result of decriminalisation of cannabis? I don't know there's any evidence for that. The main issues that our members face, the issues that our members face most commonly in our emergency departments don't arise from cannabis use. It's usually polydrug use and methamphetamine and alcohol.
So do you think, therefore, actually I'll turn to a specific recommendation actually in your submission, and if you could care to expand upon why you've come recommending this, but this is specifically in relation to closing the gap for Aboriginal and Torres Strait Islander peoples, reforming the regulatory framework for cannabis. Your submission suggests could go some way to closing the gap. Could you care to expand on why that is?
Yes, certainly. Our submission cites reports that when you look at the Aboriginal and or Torres Strait Islander population, they are greatly represented in the people who are being, put it in the reverse way. The option for the police to provide a caution, if you're an Aboriginal or Torres Strait Islander person, you're much less likely to receive a caution even where the cautions can apply. So the issue there means that for those Aboriginal and Torres Strait Islander people, it would appear on one examination of that simply because of the colour of their skin, they are becoming they are entering the criminal pathway for cannabis use at a much greater rate than the rest of the population. So that's one very clear, easy way to help close that gap. Again, drug use and overuse of drugs, whether that's alcohol and other drugs, needs to be seen as a health issue, not as a criminal issue. If we're serious about closing the gaps, it can't just be about treating the outcomes. We also have to look at the causative factors.
Thank you. Actually, I'll come back to that.
Thank you, Chair. Thank you for your submission, Mr. Waits. So the association supports quite enthusiastically decriminalisation, but I don't think you've said anything about legalisation. Do you see decriminalisation as a step towards legalisation?
I'd have to take that on notice. I don't know that we've considered that view and put that to our membership more broadly. I think the decriminalisation is a logical next step.
Okay. Well, I would just say, look, I mean, the problem I have with decriminalisation is that the drug market is a market. There is supply and demand, and if we decriminalise the demand side, then there may even be an increase in demand. So they've got to get it from somewhere. So what we're doing is, by making it illegal, or continue to make it illegal, is we're fostering organised crime. We haven't dealt with that problem at all. Do you see any merit in that argument?
I haven't seen the evidence of where cracking down harder and harder on drug use improves the situation. I think the evidence that we referred to in our report coming out of the ACT doesn't indicate that there was a big increase in the use. I also note within the ACT the ability to have some plants and grow your own means that you're not coming into contact with the criminal elements at all. You're merely growing a plant and using that for your own recreational purposes. So in that way, I think the logic should flow that less people come in contact with criminal elements who might look to trade you up, as poor use of terms there. But the more we can decriminalise it, the better the more likely it is that people won't come into contact with the criminal elements.
Okay, my last question is, so I enjoyed your couple of paragraphs on your arguing about drug testing. You're saying detection should be the key, not impairment should be the key when driving and not detection. Well, that makes logical sense. What jurisdictions around the world, because as the Chair said, there's a lot of jurisdictions where cannabis is either decriminalised or legalised. What jurisdictions do you think are doing that well in terms of having a impairment test and not a detection test?
The only awareness I have is that there are processes that have been calibrated is the wrong word, but assessed as effective. I'd have to take it on notice as to which jurisdictions are deemed, and what are the parameters around which they're assessing that. But the point there is that with medicinal cannabis, if we have members who are taking medicinal cannabis under a prescription and under the care of their treating physician, the detection of that alone can then create problems for their registration, where they may not be impaired at all because of the amount of time that it remains detectable. So we see the impairment as being an important issue, not just for our members, but for everyone.
Thank you.
Thank you, Mr. Waits. Your members, I assume that some of them are medicinal cannabis patients themselves. How is the association dealing with, if at all, the issue of workplace drug testing and impairment in the workplace? That is, nurses and midwives who may be prescribed medicinal cannabis, taking it in accordance with their doctor's directions, but then may be subject to workplace drug testing that may turn up a positive result. Is that an issue that's appearing for your members?
Not that I'm aware of. Under the processes, the regulatory bodies would look at whether or not that was a prescribed medication. They'd have to be given evidence of impairment, as opposed to people who might take drugs not under prescription and being detected, and of course having conditions placed on their registration which requires routine testing. So the pathways are quite different. If it's been prescribed, the board will take a different view.
So there's essentially a defence because they've got a prescribed. They can one of your members can provide a prescription and therefore a defence and say, like in the absence of them being impaired, and I've got a prescription, I shouldn't be subject to any penalty or deregistration if they'd been taking recreational cannabis.
If I understand your question correctly, if a nurse is questioned about their ability to practice, the things that are looked at are whether or not they were impaired and the cause of that impairment. A nurse or a midwife always needs to take into consideration their ability to practice at any given moment. They might be impaired from fatigue. They might be impaired for a range of reasons. But if we're questioning the use of cannabis, then the decisions of the board would be different if there was a prescription for the use of that medication, and whether or not the nurse was impaired whilst working, or whether or not there was simply the detection of the medication in their stream. That's the key difference.
Okay. I attended one of your conferences recently, and one of the issues that was raised that was becoming an increasing difficulty, it appeared, for your members, was how they were managing medicinal cannabis patients, in particular in a hospital setting, when they've got a mix of medications and medicinal cannabis patients self-medicating. Is that a growing concern and a growing issue for you and your members?
I can't speak to the frequency of that as an issue, but as you say, yes, it becomes a problem whether or not it's declared, whether or not the hospital has suitable policies and processes, whether the admitting doctor is willing to prescribe that. There's a range of issues that arise from that.
Thanks. One area that your submission doesn't touch on is the effectiveness of cannabis as a medicine. What are your views, the association's views on the risks and benefits of medicinal cannabis?
We can only go by the available peer-reviewed literature that's available. My understanding of the current status is that whilst there are some benefits noted, the effectiveness is still questioned. And so the reports are mixed as to whether or not the outcomes are always replicable. So it's still an area that deservedly needs further investigation as to the efficacy.
We've heard some evidence, and there's a suggestion that in effect the medicinal cannabis market is becoming a sort of a proxy for the like a legalisation. Is that something that you could comment on? And that it's essentially being accessed by some people who may not have, who their principal reason for accessing the medicinal cannabis market may not be for health reasons, but for reasons to do with recreation and relaxation. Is that something that you could comment on?
I'm not personally aware of that. It's not an issue that's been brought to us. I assume that if you are accessing medicinal cannabis, it's because you've got a treating physician who's prescribed it under the regulations, etc. So I couldn't comment.
Currently in New South Wales, there's a medical defence. We don't test for opiates, and there's a medical, there's a defence in the Act if you are involved in an accident and you have a blood test and it returns the levels of opiates, but there's a medical defence if you have a prescription for opiates. We know that opiates can be very impairing, and they're involved. The statistics show that their opiate use there's a causal link with some pretty serious accidents. Do you think that that we should be testing for opiates in roadside drug tests, or we should take away the medical defence for opiates?
We don't have a view on either of those things. We'd have to take them on notice. Again, our principal approach to alcohol and other drugs is to take a harm minimisation approach. That addiction in any form is a health issue and needs to be treated as such. So I couldn't comment further than that.
Okay, thank you. Questions from the government?
I was wondering, Mr. Waits, can you talk to the adverse health impacts of incarceration?
I'd be happy to provide a more detailed response on notice, but you know, the effects of the stigmatisation of having been incarcerated, the effects of your potential employment, isolation from family and friends, the reports of exposure to other drugs within the jail system. These are all things that are well documented. We also know from our members that work within the jail system, providing healthcare services within the jails, whether that's through public or private, that the healthcare for the patients who are incarcerated is not as good as it could be. That there are long waiting lists to get to be reviewed. That if you are transferred whilst you're on that list, you go to the bottom of the list at the next jail. And so people's healthcare concerns can take quite some time to get addressed. Urgent things take priority. And so there's some concerns from our members that health conditions can deteriorate in jail because you're not having the routine tests and checks in a timely manner.
Yeah.
Now, that's obviously not for the entirety of the population, but there are concerns for certain people depending on their transfers and time in jail.
Yeah. So there's been evidence in the inquiry so far that even the recreational or personal use of cannabis can ultimately lead to incarceration, whether by way of a prison sentence for an offence of possession or cultivate, or because it interacts with later interactions that you have with the system. So, for example, you might breach a good behaviour bond or a community service order that was originally imposed because of that, or the punishment for a later unrelated offence might be ramped up because you've got this history for being convicted of cannabis-related matters, but which is why I asked that question. But I'm interested about whether you've got any knowledge or whether you might be able to take it on notice in terms of research about the adverse health impacts of some of those other interactions with the criminal justice system. So people that might be stopped and searched on account of possession of cannabis numerous times perhaps, or people that are charged and taken to court, not ultimately jailed, but go through the criminal justice system, and whether there's adverse health effects as a consequence of those things as well.
Yeah, I imagine we could have a look at and make comment on the psychological impact of that. Yeah.
Sure, thank you, Mr. Waits. That's my question, Chair.
That's it. Mr. Murphy or Dr. Kane?
Thanks, Chair.
Any more from you, Kate?
No, I don't think so, Chair. I think it's pretty straightforward. The submission speaks for itself, I think.
Great. Yes.
Excellent submission.
Thank
Yeah,
you
good
very
submission.
much, Mr. Waits. We very much appreciate you taking the time to make the submission and also to appear here to give evidence. So thank you again. I think there was one or two things taken on notice. The Secretariat will be in contact with you in due course about those. So thank you very much for the work you and your members do and for taking the time to appear here. Thank you very much and
Thank
good
you, Chair.
afternoon.
Okay.
Thank you.
Well, colleagues, we are running a little bit We now have quorum with the arrival of Mr. Murphy. Apologies, it may have been my fault that I may have led my colleagues astray. We had a bit of a change in the timetable. But look, thank you. Apologies for the lateness. We very much appreciate you taking the time to appear and the submissions you've made. Before we begin, if I could get you to state your name and title and swear either the oath or affirmation. And I'll start with you, Dr. Kowalski.
Thank you. So my name is Dr. Michaela Kowalski, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Professor.
So my name's Don Weatherburn, and likewise I solemnly, sincerely and truly declare and affirm that the evidence now to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Do either or both of you have an opening statement you'd like to make?
Yes, I have some 6 comments, really descriptive comments, and I think you would have received a copy of those comments.
Yes, we have. So
yeah, great.
That's been tabled.
I mentioned that simply because the graph is going to be a lot easier to explain if you've got it in front of you. So these are some specific problems with the current policy responses to cannabis, and I'll just go quickly through them. As everybody here knows, I'm sure, the aim of the cannabis cautioning scheme was to divert people away from court, hopefully to avoid them receiving a criminal conviction for an offence for which they're not likely to ever receive another offence. As it turns out, though, the ratio of cannabis cautions to prosecutions for cannabis use and possession last year was less than half what it was in 2013. In other words, there's been this steady decline in the relative use of cautions compared with prosecutions, so much so that in the last year there are some 4,300 individuals prosecuted for use and possession of cannabis compared with 2,600 odd who actually received a cannabis caution. What's worrying about that, or what's additionally worrying about that, is a disproportionate proportion of those who are actually eligible for a caution are not given one. Indigenous offenders, about 74% of Indigenous offenders are prosecuted for use and possession of cannabis, compared with 39% of non-Indigenous persons who picked up for use and possession of cannabis. As you all know, I'm sure, the prosecution of cannabis users, things have changed dramatically since the scheme was introduced. More than 90% of the population in Australia these days over the age of 15 are not supportive of prosecution. We know that from the National Drug Strategy Household Survey. The preferences of most people are either no action, education and treatment, or a fine. Less than 8% now support prosecution, if that means community service, weekend detention or prison. There's little evidence that prosecution acts as a deterrent. As you know, more than 40% of the population have tried, over the age of 15, have tried cannabis. In the last, or I should say the 2019 National Drug Strategy Household Survey, there was a question which asked respondents whether or not they would use cannabis if it was legal. We analysed that data and found that less than 5%, 4.2%, said they would try cannabis if it was legal. There is, though, as you know, compelling evidence that criminal prosecution, if it results in a conviction, inevitably reduces a person's subsequent employment and earnings prospects, which is something people have to live with if they're doing things like break and enter or motor vehicle theft or armed robbery. For most cannabis users, people picked up for cannabis use will never appear in court again, but the conviction stigma attached to their criminal record will pursue them over a very long period. That's all from me. I just wanted to draw your attention to those facts, and leave it to my colleague.
Thanks, Don. I do have an opening statement, if that's all right.
Thank you, Doctor.
Yeah. So I wanted to thank the committee and the chair for the opportunity to provide evidence for the inquiry. The National Drug and Alcohol Research Centre at the University of New South Wales is Australia's leading research group in the alcohol and other drugs sector. We produce evidence-based multidisciplinary research that informs treatment, policy, and our communities regarding alcohol and other drug-related harms. Together with cannabis research experts from the Global Cannabis Cultivation Research Consortium, we've conducted policy reviews and the largest international survey of people who use and grow cannabis, in which we asked people about their growing practices, motivations for growing, and their attitudes towards regulation. In our policy review, which focused on the applicable penalties for possession, cultivation and distribution of cannabis, we found 7 different approaches across 79 different jurisdictions to cannabis in law, ranging from full criminalisation to a legal model that retained civil and criminal penalties for prescribed activities. Our findings also indicate that there is no one approach to regulating cannabis, and that adopting one type of regulatory scheme for a specific use case, such as medicinal use, is not necessarily predictive of adopting a future regulatory scheme for other uses, such as industrial use or recreational use. Our paper on cannabis growers' attitudes towards regulation is forthcoming, but I can share the findings from our respondents from New South Wales with the committee that might be of particular interest given the proposed amendments. We found that most growers agree that only adults should be able to grow cannabis for private use, and that if it was to be legal to sell cannabis, that only legal licensed entities should be able to sell cannabis. We also found large levels of support amongst the community from New South Wales for setting a limit of up to 6 plants for private grows. One of the key messages coming from international colleagues working in public health in jurisdictions that have already legalised recreational cannabis is that there are some important health-based safeguards for regulators to consider. These are restricting the local and international cannabis industry's influence on regulation, banning promotional materials and advertising for cannabis, restricting access to cannabis for minors, setting limits on the percentage of psychoactive compounds in the cannabis, and restricting where cannabis can be consumed. It's important to note that our colleagues recommend that the ideal time to put these safeguards in place is while designing the regulatory model, and that they are applicable no matter which profit model approach is adopted. I can also share advanced copies of the research that I was talking about now with the committee, and I'm happy to answer any questions. Thank you.
Thank you very much, Doctor. We would welcome that research. Is that confidential at this stage?
It's just that it's not gone through peer review yet at this stage. It's also a subset of the findings because we only looked at, I drew out the findings from New South Wales to talk to the committee today because I thought it would probably be more applicable what people who grow cannabis in New South Wales thought than the people who grew in Belgium for the purposes of today. So I've got that here from 116 people, the responses, so I'm happy to share that with the committee.
Yes,
and I've spoken to
sure.
my co-authors about that. So you need to remember that this part hasn't been through peer review yet for this piece of work.
Mm-hmm.
Could you check the time frame for that in terms of the time frame for peer review and the time frame of this committee? How long you're expecting? Is it going to be many months? Or can we expect something sooner?
So I can give you the results that we've got now. As far as the publication going through review, it's not going to, in the publication, there you go. The publication's probably going to take quite a few months, and in the publication we're not going to draw out the responses from New South Wales separately. Okay. So we, like my co-authors and I, are happy to share the responses from New South Wales today. But
okay,
yeah.
If you're happy to share them, that's fantastic. All right, we'll begin with some questions from the crossbench. Ms. Fairman.
Thank you. Thanks for appearing today. Already.
Sorry, Kate. Is that okay?
Yeah.
Oh, sorry. All right. Yeah, go with you, Kate. Sorry.
Yeah. Already. Very valuable evidence. I was wondering, Professor Weatherburn, whether you had any thoughts within the data and statistics that you collect around the reason behind the decline in cannabis cautions compared to cannabis, or the decline in cannabis cautions over the last decade.
I'd love to say I know the reason, but I don't. I'm as surprised as anybody else. In fact, it's something that I only realised in the last week or so when I was looking before coming to this committee. I thought I'd just have a closer look at what's been going on with cannabis cautions. And although the raw number of both cautions and prosecutions is going down, what's happening is that cautions are going down much more rapidly than prosecutions. That's why you're seeing a shift towards a higher proportion of prosecutions. Now, why that should be, I have no idea. There's certainly been no change in the prevalence of cannabis use, so that wouldn't explain it. I assume it's got something to do with the way in which police have decided to exercise their discretion or what they've decided to focus on, but you'd have to ask the police about that. Yeah, no, thank you. And I can see that the data that you've got goes until, it looks like, just beyond August 23. Of course, the early drug diversion initiative was introduced and brought in to
implementation, I think, in February, end of January this
Yep.
year. Data that my office has obtained suggests that police certainly are using their discretion, and in fact the majority are still choosing to charge people caught with a personal quantity of drugs. This does go to show, I think, that potentially the issues with allowing police discretion. Do you believe so?
I think that's right. I think there are several examples. This is one. Another one is the Young Offenders Act, where although the legislation specifies the criteria that police are allowed to take into account, there is always this residual discretion they enjoy which is ungoverned. And as a consequence, it's easy to find large variations between local area commands in the way in which these laws are implemented. And in this particular case, large variations over time in the extent to which they choose to caution versus prosecute people. There is one point I should probably draw to your attention, because I'm sure police would raise it, although I don't think it's an explanation for the current trend, and that is that it sometimes happens when a case is being prosecuted for supply in the district court, they will accept a plea to a possession offence. But that's a very small percentage of the cases. And in those cases, of course, the person would be prosecuted rather than given a caution. But as I say, that percentage is very small. So what you're looking at, I think, is a genuine decline in the relative willingness to caution as opposed to prosecute someone for cannabis possession.
I mean, it is extraordinary data. Do you break down in any way, or is there any research into how the different local area commands apply this? I think that I requested data broken down by local area command.
Yep.
That hasn't come back to me yet, and I assume it's available. Have you done the same?
It is readily available information. In fact, it can be obtained from the website of the Bureau of Crime Statistics and Research. But in that handout that I gave you, that single sheet, you'll find a paper published by the Bureau of Crime Statistics and Research on cannabis cautioning. Adam, I've forgotten his second name, but Sarah Rahman and Adam, that paper specifically looks at the question of whether or not the local area command makes a difference to the likelihood of getting a cannabis caution, and finds that there is a significant effect.
Right.
You know the paper I'm referring to? I handed out all my copies, of course.
Yes, well...
So it will be one of the dot points there, and thanks very much. You're very silly of me to hand out everything. So the paper in question I'm looking at here is, where are we?
And while you're doing that, I just wondered whether you could... do you also look at the different regulatory frameworks across the country and the difference when police discretion is allowed and not? Do you have any comments about that, or is it largely focused on New South Wales?
Colleagues.
Yes, Dr. Kowalski.
Yeah. So we haven't compared the cautioning rates for New South Wales and other states. As far as other regulatory schemes, I'm happy to provide them on notice, because I don't want to get this wrong, because I do have it, but I didn't bring it to the committee today. But I think my understanding is, with the exception of Queensland, and that's quite recent, every jurisdiction in Australia has discretion. Even the ACT's wording is may. I think Queensland's latest kind of amendments have changed it to make that where I think Queensland's decriminalisation is not discretionary now. But I take that on notice. I don't want to mislead the committee.
Because it would be interesting, when you're taking it on notice, because this does indicate potentially cultural shift. I don't think it could be lack of awareness of the fact it exists. These are the questions, and then whether, with police discretion in other states, whether the leadership and cultural attitudes within police forces in other jurisdictions is different to ours, and therefore I think it's an interesting interesting thing to consider whether the discretion is applied less often. That would be interesting. I have spoken with some local area commands, I won't name them, that, for example, weren't aware in an area with extremely high rates of alcohol and other drug use, weren't aware, well, let's say illegal illicit drugs, not aware of the fact that the early drug diversion initiative was even a thing. This was a superintendent, and their officers weren't using it, and this was 4 months in. So I don't know whether either of you have any comment about what type of what the police force should be informed about and how that occurs, or whether it's just, are they aware of it or not? And again, I hope we'll call the police to this inquiry to ask. But we shouldn't have discretion if the police aren't using it. It's a failure.
I don't see discretion in and of itself as being problematic. I think the problem arises when it's becoming clear that there are big variations across local area commands, or police commands I should say, in the way that discretion is being exercised. And I would have thought a sensible thing to do would be to monitor that, and it's not a difficult thing to monitor. And where evidence of big variations appears, to sit down and discuss why that might be and how to deal with the problem. Bearing in mind that there are legitimate factors that the police should consider and have to consider. It's what's left over, the variation that's left over after they've taken that into account.
And so just one last question. So just on this, I just wanted to check. You said that the data was available. So have you analysed that? Do you have that information broken down by local area command? And if so, could you provide it to the
I haven't broken down by local government area at the moment. Haven't analysed it. Could analyse it. It wouldn't be difficult to get it broken down by local area command, which would be more useful. And that information can be readily obtained from the Bureau of Crime Statistics and Research. Just one point, I misled the committee earlier about the name of the bulletin which contains this discussion. It's Crime and Justice Bulletin 258.
Gotcha.
And the authors are Sarah Rahman, and I'm afraid I've forgotten the second author's name.
Thank you.
But that looks specifically at the police command contribution to the variation.
Thank you.
Thank you. Doctor, you were talking in your introductory remarks about regardless of the models that you consider, that front-loading the regulatory reform is essential. You said there was, essentially seven different models, operating globally. But regardless of which ones you go with, that you should do the regulatory reform and the transition process well before it goes live. Is that what you were saying? Is that your evidence? And if so, why and how?
Yeah, thank you. What I was trying to say was, while weaving together, that there are certain things that, when we look to jurisdictions that have legalised recreational cannabis, such as the state of Washington in the US, there's the different states of Canada, so British Columbia, do they call them states there? I think they are states.
Provinces.
Yeah, provinces, thank you. British Columbia as opposed to Quebec. There were different things that people were taking into consideration about how they wanted to regulate their cannabis. And in Canada and some of the provinces like Quebec, they were paying specific attention to certain things that they were seeing coming out of different jurisdictions. So the idea here is that if you want to put in things to safeguard health, the time to do that is before you do your reform and not afterwards. Sorry, I'm just going to drink a bit of water. But that's what I was trying to talk about when I was talking about front-loading your reform. So, like, whichever type of model you go with, and that wasn't necessarily referring to the different, approaches from criminalisation to legal, even though that's applicable then. It was more about there are conversations that if you have a government monopoly or if you have a co-op scheme or a club type of scheme, and that people kind of think that this might be safeguarding public health. And I think the argument here is that safeguarding public health is something you should do regardless of whatever it is you choose to do.
And so, what are the key things you think need to be done? Of course, like you referred to, making sure adults could only, it's adults only. What are some of the other things you can do, regardless of the model, to safeguard public health?
So one of the things that people talk to is about setting limits on the percentage of like the psychoactive compound in cannabis. In places that don't have limits, such as Washington State in the US, they've found different products on the market with up to 70% of active THC and beyond that. And that's a concern that some public health officials bring up and people who work in mental health at district, because that can have effects. So that's one of the things that people talk about wanting to put into effect. Bans on promotional materials and advertising for cannabis. Limiting the extent of the cannabis industries in regulation is something that is one of the first things that people bring up that are worth considering.
What do you mean by that? Is it like the size of an individual enterprise, or the size of the total, globe, like the whole industry?
No, we're talking about if you were to have a regulatory body restricting people from sitting on that regulatory body if they have ties to the local or international cannabis industry.
Okay. Alcohol and gambling influence.
Yeah.
Yeah.
Okay. And my last question is, in terms of the 7 models, could you provide us more information on those, and which ones do you think are the best, and which one is the worst? If you had to pick a place in the world that you think is doing it better than other places, where would that be in your opinion? And
go for it.
Come
on. Okay, so the models are not this is not to be okay. So first of all, this is kind of early work. It's not necessarily the way that you've used to thinking about it. We were really looking at what penalties are applicable. Like who applies what penalties for what when it comes to cannabis. And we were specifically looking at possession, cultivation, so growing, and distribution. So it's when we look at that and see what type of penalties are applicable for those 3 behaviours, that's when we came up with this idea that there are kind of 7 different approaches that people take. One of them is full criminalisation, so criminal penalties are applicable for all 3 at every scale. And that's something that we saw in the state of Texas in the United States. That was very rare. I'm not going to speak about Texas, but it's probably not my preferred approach. Speaking as myself, not as NDARC. On the other side, kind of end of the spectrum, you have full legal models. So that would be what you've got in place in Canada. It's what you've got in place in a selection of states across the United States, such as California, Colorado, Washington State. And in all those places, you have a legal model, like you have a legal framework for recreational cannabis, but they still have civil and criminal penalties that are applicable for different prescribed activities, such as large-scale illicit cannabis grows. Some of the states also still ban like large-scale possession, and that can still get criminal penalties if you're found with a large amount of cannabis in your home. You can face criminal penalties in some of these states, something that wouldn't be applicable for, say, hoarding alcohol, for example. So it's worth considering that cannabis is still regulated in a different way, even when it's legal. And in between, you kind of have this whole different mix of cannabis possession only faces civil penalties or no penalties, but there'll still be criminal penalties for growing or for distribution, and that's how we ended up with the 7. I'm happy to provide that on notice. I don't have the full breakdown here, but it's really just about that kind of mix.
Okay.
The dilemma you pose, can I say, is that NDARC is not an advocacy body, so we're really here to present the facts as they're understood to be the case. Obviously, as in all policies, it's a balance of competing interests, and that's really a political decision rather than a scientific one.
Okay.
So the better would depend on your aims. So the question is better for
better
what?
if you were trying to reduce harm.
Well, they all offer the capacity to reduce harms, but you can only reduce some harms while having to put up with increases in others. So, for example, if you were to fully decriminalise cannabis use, you will see probably an increase in cannabis consumption, and that carries with it an increase in people driving on roads affected by cannabis. The benefit you get is that you've got far fewer people with a criminal conviction whose job prospects are limited. If you go the other direction and criminalise it completely, so there's no cannabis cautioning whatsoever, there'll be a lot more people with convictions for cannabis use that interfere with their job and employment prospects, but there may be fewer people driving around on the roads with cannabis in their bloodstream. So, there's no single solution which reduces all harms. It's a trade-off of harm reduction on one side versus the other.
But also, if you legalise cannabis, there's certain benefits you would get that you miss out with both of those two models that come from taxation revenue, but also about having more control over the supply and being able to put in different type of incentives to safeguard around like the percentages of psychoactive compounds in the cannabis, the quality of it.
I mean, those are definitely things you could do regardless of the model.
Thank you. The government. Do you have some
thanks,
questions?
Chair. And thanks, NDARC, for the submission. Really helpful. The first question, maybe for you, Professor, is what role do you think cannabis and cannabis regulation, or I should say cannabis regulation, what role do you think that's playing in the continuing overrepresentation of Aboriginal people in the criminal justice system?
Well, insofar as people are being disproportionately prosecuted for cannabis possession that are Aboriginal, it certainly makes a significant contribution. I think perhaps the more important concern is that states and territories and the federal government have committed themselves to reducing rates of Aboriginal overrepresentation in prison. And one of the reasons that Aboriginal people are overrepresented in prison is that they tend to have longer criminal records, and one of the contributions to those criminal records is being picked up for offences such as use and possession of cannabis when they could otherwise have had a caution.
Yeah.
So it also makes an indirect contribution to Aboriginal overrepresentation in prison.
Yeah. So how much of the overrepresentation in prison, not expecting you to quantify it to a figure, but how much of it do you think is indirectly referable to cannabis in terms of people being on good behaviour bonds, which they subsequently breach, people having sentences for unrelated offences increased on account of criminal record, and factors like that?
It's a good question, and I don't know the answer. There's no question that once you have, as you correctly point out, a supervised bond, for example, as a consequence of being picked up for a minor offence, and you breach that, that will go down as a further conviction for a justice procedure offence. And of course, if you come before a court with a justice procedure offence, that is failure to comply with a previous court order, the chances of you ending up in jail are consequently increased. So these things act as what some people call as snares. They snare you and make it more likely, should you commit a further offence, that you're going to end up in jail. They accumulate over time, if you get my drift.
Yeah. So we've got evidence before us that 91% of strip searches are for drug possession or suspicion of drug possession. I'm interested in your thoughts on to what extent are drug laws, laws that pertain to the possession of small quantities of drugs, to what extent are they being used as an avenue for proactive policing when the aim of the policing, the proactive policing, is indirectly some other form of offending? So, for example, police are using traffic and minor drug law as a way to monitor people that they might suspect are recidivist domestic violence offenders or some other sort of offending that's maybe more serious.
Well, certainly starting a few years ago, police in New South Wales began to focus on what they would have called prolific or high rate offenders, that is to say people who have a criminal record regardless of what's in that criminal record. Most of you will be familiar with the Suspect Target Management Plan, and the object there was to find keep people who are suspected of being prolific offenders under constant surveillance and constantly looking for circumstances in which, for example, if they're on bail, they might be breached, or if they're breaching a court order. And police would have argued in those circumstances they're doing nothing more than enforcing the law. And they are, to that extent, that is correct, absolutely correct. But the consequence is that you're not dealing with a situation where police are, say, facing a huge problem of armed robbery or a huge problem of break and enter and going around looking for the culprits. They're basically drawing up a list of people in each local area command who they believe to be major offenders and looking for anything they do which might be a basis for refusing bail or prosecuting the person. And minor offences play just as important a role in that as major offences do. It's what used to be known as the Al Capone strategy, as to say you go looking for whatever you can get the person for rather than deal with a particular problem, whether it be armed robbery or trafficking or whatever else. Does that make sense?
Yeah, it does make sense.
Yeah.
Like, how important is that to the police to keep those offences on the books? Do you think it culturally it's a I'll have to ask the police that, but they might not give me a straight answer. But how important do you think it is to the police for them to retain the criminality of cannabis so that they can then pursue more serious serious offences?
I wouldn't have thought that the cannabis offences play a huge role in that. They may play, to some degree, but if I was a police officer and I was looking to implement something like the suspect target management plan, the first port of call would be an outstanding warrant or a bail breach. And the reason I say outstanding warrant or bail breach is because automatically if you've got the person, you can have them locked up. It's a different story, again, if you pick somebody up for cannabis possession, then there's not going to be any automatic removal from the street. So I wouldn't have thought cannabis laws play a huge role in that suspect target management plan type thing. And I should be honest here and say that the evidence is quite strong in favour of targeted policing. The problem is that there's always got to be a balance struck between pushing crime down and unfairly intruding on people's liberty or becoming harsh and aggressive. But that's by the by. To answer your question, I don't think the cannabis laws are anywhere near as crucial as the laws pertaining to breach of bonds, breach of supervised orders, breach of bail, breach of apprehended violence orders. I mean, those things I would have thought far more important to them than cannabis possession.
Sorry, Steve.
But it's commonly a condition of bail to be of good behaviour, I think.
Yeah.
So, for example, if a person's on bail for a more serious offence and they're surveilled, found to be visiting a drug dealer's house, searched as they leave, then that could be a trigger for a drug possession charge as well as a breach of bail, couldn't it?
A breach of bail, as I understand it, is still not an offence. It's a basis for bail revocation.
Yeah.
And yes, that's absolutely true. It could happen. Although I think most of the people who get dealt with for breaching bail are dealt with for not complying with one of the conditions, not for classically being domestic violence. Stay away from the person. They don't stay away from the person. There's an immediate breach, and the consequence is they bail refused.
Yeah.
But I wouldn't doubt for a second that it's possible a breach of bail might involve a possession offence.
Yeah. So do you think the imperatives of proactive policing are a legitimate rationale to maintain a criminal offence?
Well, I would have thought no. I would have thought there has to be some inherent justification for a criminal offence other than the fact that it helps police catch other kinds of people for other kinds of offence.
Yeah.
That would be an odd justification from my standpoint. But
in terms of the cannabis cautioning scheme, we've got evidence before us about the high rates of Aboriginal people not being eligible for that scheme or not receiving the benefit of discretion under that scheme. Do you think that evidence, insofar as you're aware of it, might be a basis to amend the scheme to require police to disregard a prior history of cannabis matters?
Well, I think that would help. I think prior history is the big driver here of whether you're going to end up getting a caution or whether you're not. And to some extent that could be seen as somewhat unjust in the sense that whatever prior offences a person has done they've already served time for, and in a sense it's like double punishment to deny them a caution if that's all they've got. a small quantity of cannabis. But I do think enormous amount of attention is paid to prior record in circumstances that would make you scratch your head a bit. If a person has a prior record for break, enter and steal, it's not at all clear to me why, if they're picked up for a small quantity of cannabis, you would be denied the cannabis caution because you've done a break, enter and steal. I'm much more in sympathy with the notion that if you've been a drug trafficker and you're picked up in possession of a drug, that would make more sense to me. But look, I'm speculating here. I don't know.
But about that. But the rates, like when we talked about this before, though. So one of the first studies that was done for the cannabis cautioning, this is Boxar's work, so not NDARC's, the initial evaluation found a difference in the rates of cautioning for people from Aboriginal and Torres Strait Islander backgrounds and people who were not. And they also found that when they followed up a couple of years ago, and they, I think we made reference to both in our submission to the committee to see that it's like a long-standing problem. The points of difference that Boxar identified were really structural, that there were fewer people, percentage-wise, fewer people from Aboriginal and Torres Strait Islander people were eligible for the caution in the first place, and a lot of that difference had to do with the requirement to not have a criminal record for offending that was drug-related. But also amongst people who were eligible who didn't have that, there was also a difference in having an existing prior criminal record. So if that were to change, logically those numbers should change dramatically as well.
Yeah, it's a bit of an unusual thing because normally the policy of the criminal law is to have regard to prior matters, whether that might help in some unusual senses or might count against someone. It's fairly unusual to have a scheme that requires disregard of prior history, but I just wonder if the rationale for this offence is seen to be less in terms of it being a health issue and so forth. Maybe there is a rationale for excluding consideration of prior matters.
Well, you don't get tough penalties for parking because you've had 40 parking fines before.
Yeah.
You get the fine.
Yeah.
If you were to think of a small quantity of cannabis possession in the same light as an infringement notice, you would be sanctioned.
Yeah.
But the sanction wouldn't depend on how many times you've been sanctioned before.
Yeah.
For this offence. So I guess it depends on how you want to look at the thing.
Yeah.
Is cannabis possession more akin to an offence like burglary, where criminal record is clearly relevant, or more akin to a minor offence deserving of an infringement notice or a caution, where if there's going to be a sanction, it wouldn't be one that would get worse every time.
Yeah. So the other thing I wanted to ask was, a lot of the evidence we've received is premised on the dichotomy between criminalisation and decriminalisation. And you've probably heard that the Premier has ruled out the decriminalisation of illicit drugs, at least in this term of government.
Right.
And I'm interested in things in that criminalisation space where you could perhaps relax criminalisation. And some of the things that occurred to me was you could change the maximum penalty for possession from 2 years and move it down. You could change the definition of supply so that giving away drugs to friends is possession rather than supply. You could change the police powers laws so that you couldn't stop and search and strip search on account of a suspicion of minor possession. And I was wondering if you had any other ideas about how you could relax criminalisation without removing it altogether.
I don't.
Well, you've named quite a few of the options. In different jurisdictions around the world, small-scale supply, particularly supply that's referred to as gifting, so without the exchange of money, that's not treated as supply across the board. There are jurisdictions that do, but there are also jurisdictions that have civil penalties for that, or also just regarded as part of possession, which is, I think, what you were talking about. You could also do that with things like growing, so production. There are jurisdictions that treat that as akin to distribution.
Yeah.
And there are also jurisdictions that treat that as akin to possession. So that's one of the places that there can be movement as well. Another thing is to kind of move towards a blend that's more towards a mix of civil penalties and criminal, or move towards civil penalties. You can absolutely reduce the severity of those penalties. There's big variation in like how severe a penalty is for these things. So those are all things that you can kind of play with.
Yeah, that's interesting. So the other thing we've got evidence on is the possibility of changing the Crime Sentencing Procedure Act so that the default position is no convictions for cannabis possession, and one would only be convicted if the court was satisfied as to a certain threshold or test. Have you got any thoughts on that?
I think they're all worth pursuing, but they all need to be evaluated. I mean, I think the last thing anyone wants is what's happening with methamphetamine, which is a huge increase in people entering hospital with overdose problems.
Yeah.
But I don't see that as a huge risk at all. So I certainly think those things are well worth, that you've described, are well worth exploring.
Yeah.
Principally because they reduce the current harm associated with prosecution and conviction. It's not a situation that anyone can be terribly happy with if someone who is otherwise leading a normal, lawful community life is picked up for a small quantity of cannabis and has that stain on their criminal, on their history, affecting their job prospects and employment. I think that's the big harm that needs to be considered in looking at ways to reduce that without at the same time exacerbating any drug-related harm that might be of concern to the public.
Yeah, just on that. So do you think those steps where the criminalisation regime was relaxed but not eliminated, do you think that they would lead to any significant increase in use? Or do you think people's behaviour is not really driven by the minutiae of the criminal law in that respect?
I don't think it would lead to a big increase, and the reason I say that is that if you take people at their word, the National Drug Strategy Household Survey asked people would they try cannabis if it was legal, that is to say without any criminal sanctions whatsoever, and only 4% said they would. Now they're the percentage who would actually try it. The percentage who would use it regularly would be smaller than that.
Yeah.
So I think the market for cannabis over the many years that it's been available has reached almost saturation point. The bigger concern would be people driving under the influence of cannabis, and we already have effective laws for dealing with that problem.
Yeah.
Thank you, Professor, and thank you, Doctor. We've unfortunately our time for questions has ended. Again, apologies for the late start.
No problem.
That is all my fault, apparently. We looked at the tape and I got the time wrong, so apologies. I think there was a few questions taken on notice, or there may well have been. If there were, then the Secretariat will be in contact in due course. But thank you very much for your submission. You've taken the time to give evidence and also the work you do in a really important area. So thank you very much.
Thank you.
Thank you.
Good
Thank
afternoon.
you.
Thank you.
Afternoon. Good afternoon. Before we proceed, gentlemen, if I could just get you to state your name and title and swear either the oath or affirmation, and we'll start with you, Mr. Gaskell.
Yeah, James Gaskell, a Chief Operating Officer of ANTG. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Cantello.
Yeah, sure. Mr. Matthew Cantello, CEO of ANTG. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Do either of you or both of you have some introductory remarks you'd like to make before we turn to questions?
Just a very brief summary on our activity, just for clarification, if any is needed. Very briefly, we were founded in 2015, pre-legalisation, as a New South Wales hemp business, endemic here in the state. Since then, since legalisation, we've expanded to 3 sites, 2 of which in New South Wales, 1 in Armidale, which is our big cultivation manufacturing facility. Our activities are essentially pharmaceutical grade production, cultivation, manufacture and distribution of medical cannabis in various forms, namely flower, oil and inhalation formats. Our major markets are Australia, by far, New Zealand and the European Union, specifically Germany. We've also conducted cannabis-related businesses in California as well, so we're reasonably well versed in how the global markets work. Our emphases are sort of, if you like, domestically are on high quality production. We are sort of honest about the profit motive inside our business, but also we sort of pay special attention to clinical research. Our products and cash are variously involved in 11 different clinical studies using cannabis materials and medicines, and a fairly big emphasis on healthcare professional or HCP education. So we devote quite a lot of our resources in that direction to try and sort of, if you like, foster greater understanding and destigmatisation of the medicine that we believe in.
Fantastic. Thank you very much. I'll turn to questions from the opposition.
Thank you very much for coming today. Just in relation to your submission, first of all, I just wanted to ask you if you could elaborate on what steps the TGA has actually taken to address the anti-competitive practices that you refer to.
In terms of the closed, I think we describe it as closed loop activity. Well, it's essentially twofold. It's the investigation of prescribing practices and the medicines prescribed therein, if you like. And then there's a fairly large-scale inquiry into various entities around advertising practices. So we as an industry are clearly are obliged not to induce or encourage the use of cannabis. And there's arguments that has been happening. And then equally inside these closed-loop environments, the allegation, I think, is that there are certain products being preferred over others, should we say. And the alleged motivation for that might be seen as commercial rather than patient outcome.
And do you think the steps that have been taken thus far have gone far enough, or are being potentially too restrictive?
Too early to say, I think. It's a recent thing, this sort of crackdown, if you call it that. So we're in the very early stages of really the investigation. So it's impossible to say.
The other is you talk about the current framework, I suppose, doesn't have the balance between the public health and also economic benefits. Could you just elaborate a little bit more about what benefits that you see from a state perspective that we're missing out on, whether it's purely from a jobs perspective or is there something further?
Jobs and research. I mean, the industry sort of gets very hung up on the intrinsic imbalance between Australian-generated product, manufactured product, cultivated product, however you would characterise that, and then the imported product that comes from one jurisdiction in the main, which is Canada, which has had a history of sort of commercial underperformance and therefore a surfeit of product and therefore the ability to send product elsewhere in the world very cheaply. There's two competing priorities in there. One is sort of the establishment of a domestic industry, and the other is, put bluntly, financial. That's the intrinsic sort of friction that we see. And there is an argument that, on the one hand, from an industry point of view, job creation, knowledge creation, and so forth is being hampered by the free availability of imported product. And then equally on the previous point around closed loop behaviours, it could be that the cheaper products or the products with higher gross margins are preferable to a particular type of transaction where the Australian grown product might not be. And that there is a question around the efficacy of the imported product versus the higher rigour that's applied to the Australian domestic product.
And do you have any, I suppose, research or work that's done around the actual financial side of that, whether it's Australian manufactured versus import from overseas and what benefit that has to a country? Yeah,
we're only intrinsic, sort of endemically in our business, we can see the difference between imported product and domestic product in terms of cost to produce. So that's for us fairly straightforward. I mean, we wouldn't call it research, it's a sort of more of a day-to-day experience. And the relative benefit of that is purely, I think, and as far as a company can measure it, financial, but also from an outcomes point of view, there's an argument to say that the medicines produced by an Australian business in Australia with an interface to the Australian healthcare professional community has a more specific target to aim for when it comes to the production of medicines.
And finally, just in relation to, I suppose, how businesses operate here in New South Wales, what restrictions do you currently see that would prohibit other companies entering the market?
Again, it kind of a lot of it comes back to two things. One is the free availability of imported product, which is it's very unshackled by comparison to what we've done, sort of organic growth of a business. So you can be up and running in terms of a New South Wales health permit and a Department of Health TGA level federal permit very quickly, let's say 60 to 90 working days. A minor change or a major change of business processes inside the TG ages can take up to 190 working days. So we're robbed of agility. We also have a larger cost impost because we're carrying infrastructure costs, we're carrying employees, we're carrying all sorts of obligations around our day-to-day that the more nimble sort of import businesses don't have to deal with.
Okay, thank you.
Okay.
Not at this stage. Come back to me. Come back to me. Yeah.
Mr. Ruddy?
Thank you, Chair. Gentlemen, thank you for your submission, which I enjoyed. Now, you included this line: Canada and many US states have adopted commercial models that have led to increased availability, reduced prices, and the introduction of new cannabis products. These models have shown both positive and negative public health outcomes. So my first question is, what are the negative public health outcomes that we've seen from an increased level of cannabis consumption?
I think the reference there is what we don't know and what we need to know about cannabis is its potential interactions with other drugs. I think that we have seen certain, and I should caveat, nearly everything we talk about in cannabis is anecdotal because we don't have a whole bunch of research that underpins many of the assumptions that people in general might make, and that's certainly not something that we ascribe to ANTG in terms of those assumptions. But drug interaction is a big thing that I think we are understanding now. In a market like Canada or a recreational market like the US, where it's essentially untrammeled, there's no filter through which the majority of cannabis products are pushed, there's definitely considerations around the quality of the product, and by quality not necessarily, I don't mean potency, I mean heavy metals content, pesticide use, drug interactions. So at least three, major things that are of concern to prescribing partners are things that go without any close scrutiny at all in those markets.
Okay,
and I might add too, just in those markets where it's now fully commercialised, that the proliferation of dispensaries on every street corner is not necessarily a good thing for the society in general, and or cannabis and the stigma related around it. We don't believe in that model. Thank you.
And then you did, so you've said these models have shown both positive and negative public health outcomes, highlighting the need for careful regulation. So here in Parliament, we're sort of grappling with what is possible, politically possible. But if we put that question aside for a moment, what do you believe is the ideal level of regulation around cannabis, and what jurisdiction in the world do you think is the one that we should be sort of learning from the most?
I think our personal recent experience in terms of frameworks, we've lived through the German change, which became effective on 1 April this year. It sort of contemplates three major things. One is home cultivation, which we don't, feel particularly strongly about in terms of that being a threat to industry, and that's very much a personal prerogative, I think, and probably one that should be contemplated with limits, which is probably a pragmatic thing to do. The second thing is consumption spaces, which is, again, we think probably pragmatically sensible, where people can, if they wish to, consume cannabis together. That's, again, don't see anything wrong with that. The third thing is the rescheduling of cannabis from a narcotic down to a regular medicine. That piece of liberalisation, if you like to call it that, is really important for a number of reasons, because it for our perspective, it maintains that quality, it maintains the oversight of a doctor, it maintains the existing supply chain, which is really important from an investment point of view, perhaps a little bit more selfishly, where we look at, okay, there's been a liberalisation, a decriminalisation change. That doesn't mean a free-for-all in the Canadian or US model where there's retail opportunities at every street corner. What it does is it allows a more widespread mechanism for the distribution of cannabis through a prescriber, but straight to a pharmacist. No need for special access schemes or authorised prescribers in our context, but it maintains the level of safety, scrutiny over interaction, and supply chain efficacy and security that we think is very important. The way that Germany's rolled that out has been pretty good. There's a bit of thinking to be done around retrospective and retroactive convictions for cannabis use and things that don't necessarily sit inside our purview, but we can certainly see are being considered by distribution partners there. So long story short, I think that's certainly the strongest precedent we've seen for any kind of, call it liberalisation, around the access to the medicine.
Thank you. Within Australia, the Office of Drug Control is handing out the permits and licences for production of medicinal cannabis. And you've touched on the issue of the different regime for Australian cultivators when compared to people importing. What proportion of cannabis that's currently in the Australian medicinal cannabis market is imported, and how much is homegrown?
Yeah, look, it depends on the quarterly figures that you look at, but we're looking at probably 70-30 traditionally, and that gap could be starting to sort of bridge more to 60-40, but it's roughly in that space.
Okay, and is there any regulation or statute or guideline that you're aware of that the ODC has to limit the amount of import? Is it just it's just a laissez-faire, just the market operating? If people want to import it, they'll import it no matter what. There's no regard for the domestic producers when they make approve those licenses and permits.
That's certainly what we've seen so far. There's certainly been no quantities or capping or anything like that discussed with us. It's very much been around compliance to the permitting process and the speed of the import. It doesn't seem to be looked at on a sort of more macro level.
Yeah, we're obliged to obviously report to the United Nations on quantities, starting material and finishing material at any given period, and that's provided to the United Nations. And at the moment, there's a fair bit of product that's opening balance, you might say, at the start of a quarter. So that's certainly not sitting necessarily in our vaults. It could be the importers' vaults, it could be our competitors' vaults. Not sure, but there's a fairly substantial starting amount each quarter.
Okay, and within Australia, you've got a facility here in New South Wales. I understand you've got one in Queensland. Is there a different regulatory environment across states, and some of the states or territories better to do business in? If so, which ones and why?
Very slight variations in the state level sort of poisons handling regulations. Queensland's slightly more liberal maybe when it comes to its deference to the TGA, but negligible in terms of doing business. I think if there is a state that where there has been some sort of positive noises made, it's probably been Victoria. But from the point of view of a direct comparison between the states, from our experience, I think there's no difference between doing business in New South Wales and doing business in Queensland.
And are any of the states or territories really taking the lead on seizing the opportunity, if there is one, of growing a medicinal cannabis industry in their various jurisdictions, either by direct financial assistance or policy, anything like
policy,
that?
like I say, probably historically, I think Victoria's been quite vocal about the sort of educational side. I think from the point of view of access to infrastructure funding and job creation funding, New South Wales is pretty good. That's certainly been our experience in Armidale. And Queensland sort of really have yet to show any hand on this, though, that we haven't seen any cannabis-specific stimulus manifesting in any policy. But New South Wales, I think, of any of those three, which we've had a reasonable amount of exposure to now over the last 9 years, has been specifically proactive about the regions, and I think cannabis is seen as an opportunity within the regions.
Okay. And just in terms of your facility at Armidale, how big is it? How many people are employed there? Can you tell us a little bit about it?
Sure. It's an 11-acre site. It's a 4-bay greenhouse, so it's a controlled climate environment, cultivation environment. There's a genetic breeding area. There's a propagation area, and there's about 10 multi-purpose GMP manufacturing clean rooms that we do various activities in. Everything from trimming flower through oil production, extractions for oils, and so forth. So it's a fairly large facility in the Australian context. Overseas, in Canada or the US, for example, it would be seen as quite small. There's about 110 people employed there. About 95 of those, I think, but probably could come back to you on the actual numbers, full-time. And then there's a sort of rolling roster of casuals from the local community and from the University of New England.
Fantastic. And what are the prospects for Australian medicinal cannabis? How is it considered globally, if you consider the oversight of the TGA and the ADC and your GMP process? Is there a growth profile globally for Australian cannabis? Is there a big global opportunity there?
100%. I think, first of all, TGA GMP is globally renowned. So the Australian gold standard when it comes to pharmaceutical production is without parallel. We see partners or friends in other jurisdictions, Colombia, for example, seeking out Australian TGA approval for their sites in those countries just to help them with their global reputation. I think although it's easy to complain about, our regulatory environment's pretty good. We're not nimble, but we get there. I think our reputation for quality, for purity, and for innovation is pretty strong internationally. I can tell you that one of the reasons our German partner has seen consistent market share from our Australian products over there is consistency, quality, and the Australian kind of sheen. They use the grown in Australia kangaroo on the German language packaging. It's seen as something of a differentiator, so pretty strong in the export markets. Equally, I think the interface that our industry is increasingly having with academia and the healthcare professional industry bodies is also something that's not common in the industry, so we're doing a good job. There are always skeptics, and we understand that. There's a lot of work to do when it comes to education, but we have really good engagement with the universities and those communities, and that's something else that I think helps us grow the potential that we've got.
Thank you.
Thanks, Chair.
The government.
Thank you for your
Mr.
evidence
Lawrence.
and submissions, gentlemen. So my question is, I have heard it said, and I don't repeat it in order to endorse it, but I have heard it said that the legal cannabis industries overseas have been infiltrated by organised crime and are used as a way for organised crime to raise money. Is that something that you can speak to? And I only raise it in the sense that it could be considered a regulatory risk, for example, if we were to proceed with legalisation, that it might somehow become an avenue for organised crime to fundraise.
Have not really heard of that ourselves. I mean, there's a company called Juicy Fruit in Europe which had a fair bit of attention and public scrutiny. I believe that's been squashed, and the criminal gangs, I suppose, that were in charge of that are hopefully being brought to justice. But we have not seen or heard of that. I mean, the United States is a very large, complex place, so I wouldn't want to speculate, but it's very different in each state there. But we have not had any exposure to any organised crime, certainly not Australia.
I mean, I suppose a layperson might say, well, it's previously been illegal, so the people that are going to be most adept at growing it are going to be the people that were growing it under the old regime. So therefore, you might expect to see that. Have you got any comment on that?
The fit and proper testing that the ODC does for any licence holder is pretty extensive. I don't think you'd get any criminals getting past that.
Oh, okay, so what's that? Could you explain that to us?
Well, basically you need to submit its application to the federal police for a referral back to the ODC to say that you're clean. You haven't had any criminal charges for any reason over the past 5 years. So unless it's outside of 5 years, it'll be captured in those reports.
Yeah, okay. So to the extent the market here might grow and have approval for different purposes to cultivate, you could certainly construct regulatory regimes that would ensure that you could keep any organised crime involvement out of the industry.
I believe so.
The cost of doing business, frankly, inside this cannabis supply chain is probably pretty preclusive for those guys who were enjoying the bigger margins back in the old days, because it lends itself more now to efficient manufacturing practices and kind of good management than it does to opportunism.
Okay, and why is that? Because illegally it's so profitable that...
Throw some plants in the ground, grow them, dry them, sell them, where we have to do, multitude of steps, employ a multitude of different skill sets, and then incur a whole bunch of different types of costs just for distributing finished products. So, your margins just move downwards, and I think as that contracts, and it gets less attractive for unscrupulous elements because it's just not worth it.
So there wouldn't necessarily be any greater motive for organised crime to be involved in that industry than in ordinary farming, for example.
Opioids, poppy farms, no reason for them to be involved in that either.
Sure, thank you. Thanks, Chair.
If there were regulatory changes in New South Wales that you would like to see to help grow your businesses, what would they look like?
I'd go back to probably the scrutiny around the imports. It's a state level thing as well as a federal level thing.
How is it a state level?
In terms of the poison storage, there are always two levels of negotiation or two levels of of approval that we need to go through. One is federal, which gets the most airtime, but the second is always state.
So there's a requirement under that Act in New South Wales to have like a bonded area or a designated area for the storage, and the New South Wales, who oversees that? Is New South Wales Health?
Yeah, yeah. So that, look, that's not a sort of acute accusation by any in terms of how they might be hampering or helping, but I think that certainly it could be examined, but that's probably from a strictures point of view the only thing we can see. The flip side of it is, I think, as I said before, that the willingness to engage on industry growth in New South Wales could always be expanded upon, but good start.
Right. Any other questions, colleagues? None? Well, look, thank you both for your evidence. We really appreciate it, the submission you've made, and the great work you're doing in pioneering what's a very important industry, I think, with a big future in this country. So
thank you, Chair. Thank you, committee.
Thank you.
Spiel. But yeah, again, thank you very much for all the work you're doing. We really appreciate it.
Thank you.
Thank you.
Thank you.
Thank you.
At the Portfolio Committee number 1 inquiry into the regulatory framework for cannabis in New South Wales. Before we hear from you and questions, could I get both of you to state your name and position title and swear either the oath or affirmation, and we'll start with you, Mr. McCrone.
Thank you, Chair. My name is Matthew McCrone. I am the Industry and Government Engagement Lead for Montu. And I'll take an affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr. Strong.
My name is Edward Strong. I am the Head of Government Relations at Montu. I will take an oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. Do either or both of you have some introductory remarks to make?
I have a brief opening remark.
Thank you, Mr. Strong.
On behalf of Montu and the approximately 70,000 patients in New South Wales who have been seen by our clinic, we would like to thank the Chair, Deputy Chair and Committee members for the opportunity to lodge a submission and appear before you today. My name is Edward Strong and I am the Head of Government Relations at Montu, and with me is my colleague Matthew McCrone. Matthew is our Industry and Government Engagement Lead and has spent 23 years working in senior positions for both the Australian and Victorian governments. Matthew was a senior pharmacist at the Therapeutic Goods Administration, TGA, and was the Chief Medicines Regulator in Victoria. It was in that role Matthew led the task force that legalised medicinal cannabis in 2015 and also led the implementation of Safe Script. I grew up in the New South Wales village of Jugiyong and Matthew is from Temora, so we both firsthand have an understanding of the challenges of regional access to healthcare. Founded in 2019, Montu is now Australia's largest health tech business with a focus on medicinal cannabis therapies, and there are several arms to our organisation. Our patient clinic, Alternaleaf, is an end-to-end online platform that allows patients to receive care from highly trained nurses and doctors. Our wholesale company, Leafio, provides pharmacies with access to medicinal cannabis products, and our training platform, Saged, provides medicinal cannabis education to clinicians. As you will have seen, our submission explores 4 key areas: the use of medicinal cannabis in Australia, its increase in uptake and the barriers to expanded use, the impact of drug driving regulation on medicinal cannabis patients and the need to amend the Road Transport Act to protect these patients, the impact of workplace drug testing on medicinal cannabis patients and the opportunities to improve regulation, and the importance of telehealth for medicinal cannabis patients, particularly those in regional areas. I'd again like to thank the committee for holding this inquiry.
these are really significant issues for many of our patients, and we welcome any questions you may have.
Thank you, Mr. Strong. We'll turn to questions beginning with the opposition. Mrs. McLaren-Jones.
Thank you very much. I'm just interested in finding a little bit more about access to medicinal cannabis for rural and regional patients, and what the limitations are in accessing a doctor to prescribe, and is telehealth the only solution?
Well, thank you very much. It is incredibly difficult for regional rural patients to access healthcare in general, but particularly medicinal cannabis as a treatment pathway. Only about 5% of GPs are able to prescribe medicinal cannabis, and as such, most bricks and mortar GPs, particularly in regional areas, might not be able to prescribe through TGA's two pathways. That causes real challenges for those patients who are looking to access medicinal cannabis. Very often medicinal cannabis is as a treatment of last resort, and so for many of those patients, telehealth is the only option available to them.
If I can just add to Mr. Strong's statement, I mean, another significant barrier to patients in rural and regional areas of being prescribed medicinal cannabis is they can't drive while they're being prescribed it. So for them to drive to a doctor's appointment and then to the pharmacy would not be practical under current laws. So telehealth really does offer the solution for that reason.
And are there barriers for GPs becoming prescribers, or is it just a choice that some are not taking up?
When I was running the Medicinal Cannabis Task Force in Victoria, the Victorian Law Reform Commission looked very thoroughly at what would be the best model moving forward, and the model that it recommended imagined a future where a person could go to their GP and the GP could prescribe medicinal cannabis just as they'd prescribe their antihypertensives or whatever else, and that hasn't been what the reality has come to be 10 years down the road, and the reasons for that are many. Stigma is one, whether it's that specialist colleges aren't really strongly endorsing the use of medicinal cannabis, whether it's a lack of training or education. GPs say that their patients come to ask them about medicinal cannabis and they don't know what to say. As much as the TGA access pathways do work, they are complicated, and for a normal GP wouldn't necessarily be engaging on a day-to-day basis with the TGA in the way that TGA access pathways for approved medicines work. So it's complicated, and that makes it even more unlikely for GPs to take it up. But I think the major problem is still with stigma.
And final question, just in relation to your recommendation around Work Health and Safety Act, and what changes you would like to see.
Yeah, thank you. It's incredibly challenging for a lot of patients when employers have drug testing programs, randomised or otherwise, in the workforce. As some of you might be aware, and I'm sure Mr. McCrone can go into a little bit more detail about the pharmacology of THC, but THC takes a lot longer to break down than the impairment actually lasts. And so you have a number of people, patients of our clinic or others, in the workforce, unimpaired, but still with THC in their system. And if they are subject to a drug testing program, that's incredibly challenging for them. They have the potential to lose their job. We are in no way saying that impaired people should be at work, but the unimpaired, which lasts, for, as I mentioned, for a lot longer, should be able to return to the workforce.
Yeah, the idea that safety critical roles need a regulatory framework around them is without question, but it's what is being done to ensure that the employees who are in those safety critical roles are being properly protected. And this surrogate measure of presence of THC, it's scientifically questionable that it's an appropriate proxy for whether or not a person is able to do their job safely. Ed touched on the pharmacology. You know, blood alcohol concentration is something we all know and we've known for years. You know, roadside testing for alcohol has been around for 40 years, but alcohol's kind of unusual in a way to other substances in that because it is so short-acting, because it takes such a short amount of time to go through the body, the amount in the blood is very much, there's a linear correlation between that and the amount that you are impaired. That's not the case for many other substances, and it's particularly not the case for cannabinoids. The physical properties of THC particularly, it's attracted to fatty areas of the body. So it sort of goes to those fatty areas and it stays there for a very long time. That can be days, that can be weeks. But the impairment, if any, and when a patient's taking something chronically, there is question as to whether there's any impairment at all. But if there is any impairment, it's gone within a few hours. So the proxy measure of the level of THC in a person's blood is actually not an effective measure of whether or not they're impaired. That's all we're saying.
Then how, I suppose, what is the most effective measure of someone's impairment, whether they're operating heavy machinery or driving?
Yes, well, indeed, that's probably the area of policy that does need to be worked on. We recently appeared at the Victorian Parliamentary Inquiry into Workplace Drug Testing. There was a lot of talk there about technology solutions, whether it's an app or whatever else. The Druid app is one that's being used at the moment for the closed road trial that's happening in Victoria for driving. There's sort of mixed views on that sort of technology, not least of all because it needs to have a baseline to an individual person rather than, there's a universal baseline and if you score less than 3 then you're impaired or whatever it is. But there certainly needs to be more work in that area because to measure the concentration of a substance that has little or no bearing on whether you're impaired or not it's just not fair. And further to that, the number of substances that do cause significantly more cognitive impairment that are not tested through workplace drug testing programs just further demonstrate the inconsistency and the injustice of medicinal cannabis patients particularly not being treated fairly.
And are there any, I suppose, international work that's being done? So there's an app that's potentially being looked at in Victoria, but is there anything else internationally that can be used as a safe measure that you can actually say in a workplace or for a person driving that you're not impaired?
In terms of driving, and we have had a position paper developed on this with an academic who's specialises in road safety. There is actually, and again, I don't mean to be constantly plugging Victorian arrangements, but the ones I'm most familiar with. There's a behavioural impairment testing program that the Victorian Police have developed. And since 2000, everyone who goes through officer training is actually trained in this. And not to diminish it, but it's effectively there's 2 stages to it. There's a behavioural impairment screening that can happen there, right? Roadside. It only takes a few minutes. The vast majority of people would pass that initial impairment test, that behavioural impairment test, so we would envisage that they're still tested. Medicinal cannabis, if it's present, they then do the roadside test, and on the rare occasion if they fail that, then there would be a more comprehensive test that would need to be done at a station or whatever. That program exists. Officers are already trained in that. So it's not requiring technology, it's not requiring new resources. We see that as a fairly pragmatic solution, and perhaps even to say, New South Wales could look at a medical exemption trial, and as part of that trial, New South Wales Police could look at the behavioural impairment testing as part of that trial, and it could be tested, evaluated at the end of the trial.
Thank you.
Ms. Fairman or Mr. Ruddick?
Thank you, Chair. Yeah, because of course there's the situation of Tasmania, which I'm not sure whether you mentioned in your responses then, but they of course haven't. They have been able to survive with no real increase in fatalities or accidents in terms of their situation, which has been different to the rest of the country, and they're often raised. Would you care to comment about how Tasmania deals with the issue of drug driving?
So it is a general exemption. If a driver is pulled over and they are able to demonstrate to the officer that they have been legally prescribed medicinal cannabis, then that's the end of that. Now,
and their proof at the time, so when they're pulled over, do you know the details of that proof?
Well,
of what they need to provide?
Therein lies the rub. So, firstly, we would love to see data from Tasmania as to, what had they done any sort of analysis of increased incidence or otherwise since they've brought this in. But the quirk about Tasmania that's probably not really understood well is that when we talk about legally prescribed in Tasmania, that means it has to be prescribed by a medical practitioner who is resident and present in Tasmania at the time of prescribing. So we've talked about why telehealth is a solution for many patients who can't otherwise access medicinal cannabis. Telehealth is actually not a solution for patients in Tasmania because they need to have it prescribed by a Tasmanian doctor in order for it to be legally prescribed and therefore be able to have the exemption for driving.
Interesting, thank you. I did want to turn to a slightly different issue that I have been contacted about by a alcohol and other drug stakeholder with concerns about, are you aware of the requirement in terms of prescribing unregistered Schedule 8 cannabis medicines in New South Wales to not... So basically, if somebody is a drug-dependent person, they, I understand, are unable to be prescribed that. And as a result, there's been quite an increase, particularly in recent months, by, as I understand it, this kind of people who are on opioid treatment programs from being essentially told by various providers that they can no longer, they've been discharged basically, and this is happening at an increasing rate. Would you care to comment on that?
State-based poisons legislation is state-based, but more or less the same across all the jurisdictions, and in broad terms, as long as a doctor checks safe script, that's all they need to do for most patients. For a patient who, and the wording's different in different jurisdictions, but if they have reason to believe that a patient has substance use disorder or they are known to have substance use disorder, then they have to get a permit from, and again, the terms permit and approval, a license, whatever it is in the jurisdiction, before they actually can even commence prescribing any Schedule 8 for that patient, including medicinal cannabis. That is quite a regulatory burden for a lot of medical practice. It's something we're looking at in our clinic because it's particularly burdensome, in a telehealth model. But yes, so what is happening with patients with substance use disorder, including opiate use disorder, because that permit is required legally before a prescriber, a medical practitioner can even commence treatment, a lot of medical practitioners see that as too hard.
And so would it be fair to say that potentially this is also as a result of people getting medicinal cannabis online as well as telehealth, the increase in that type of prescribing, it potentially is more burdensome, that having to go through those requirements as opposed to a GP who knows their patient. Like, is that potentially one of the
there are policies.
Disadvantages?
Yeah, it's a disadvantage. So each So the Pharmaceutical Services Unit within Ministry of Health here would have a policy around what needs to happen in order for a treatment permit to be issued for a patient with substance use disorder in order for them to have S8s. And it might be, for instance, that they have to have a letter of endorsement from a specialist, that the GP that's seeking the permit has to provide all of their primary care. Conditions like that, they're not overwhelming, but it's a higher sort of...
Probably cuts into the profit margin a little bit to be like... These people are just being booted off, as I understand it, is the feedback I'm getting.
I hear what you're saying. I mean, we
is
are...
it just New South Wales specific? Sorry, just...
No,
Okay.
every jurisdiction does have the requirement that if a person has substance use disorder, that there needs to be this permission issued beforehand.
Right.
We are honestly looking at how we can work through that.
Okay.
But, the least of all, the requirement that it is the medical practitioner who's receiving the permit is responsible for all of that patient's primary care is difficult.
Interesting. Thank you. I'll come back.
Just a quick one, Mr.
Yeah,
Chair.
Mr.
Yes.
Ruddick.
So, Mr. Strong, you mentioned in your opening statement that there's a problem around the Roads Traffic Act, and we've heard from other people, witnesses, who said this. There is a problem. So, about people getting medical marijuana and not being impaired and driving and getting in serious trouble with the law. So, what do you think is the legislative fix?
Well, thank you, Mr. Ruddick. There is an existing component within the Act, Section 111(3) through 6, I believe, that deals with the provision of morphine, such as that it allows for a medical defence for those who have been prescribed morphine and then who have driven to appear before a magistrate and be able to prove that prescription. What you would need to do is allow for medicinal cannabis to sit alongside something like morphine, or to be able to take a more robust approach and acknowledge that should be all prescription drugs where there is no actual impediment on your ability to drive. At that point in time, you're no longer under the influence of it, and attach that alongside those provisions of Section 111(3) to 5.
So, where it says morphine, just add in morphine and...
medicinal cannabis.
Right. And is that... I was interested to hear... I didn't know about this Tasmanian thing. So, is that effectively what's happened in Tasmania?
I do believe they have. It is a defence in Tasmania,
but
as mentioned, there are a number of other restrictions around Tasmanian patients requiring treatment through a Tasmanian registered doctor.
And Mr. McCrone, you were saying about the Tasmanian thing. You're saying that the prescription is an automatic defence. Now, I'm all for liberalisation. Is impairment a factor in Tasmania, or is it just the prescription gets you off?
My understanding is it's just the prescription.
Yeah. Okay.
But it may be, and we could take this on notice perhaps, that the requirements in order to get the permission through Tasmanian Department of Health and Human Services are one where the doctor actually has to make an assessment of the patient as to whether they're fit to drive or not. I don't know, but it could be that there is some sort of assessment done at that stage.
I see. Thank you.
Thank you. Mr. McCrone, we heard evidence earlier today from the College of GPs saying that there was little or no, I might be paraphrasing, might be verbaling for the doctor, but there was limited or poor quality, words to that effect, evidence on the efficacy of medicinal cannabis. And that was one of the principal reasons. It was relatively new, not a lot of research, the efficacy of it, and that is why we don't have as many GPs prescribing. What's your response to that? Is there evidence we can look to? Could you respond to that?
I say, thank you, Chair, I say respectfully that medical colleges tend to be quite conservative in their positions on things, and that's for them. In terms of evidence, there is often talk of the hierarchy of evidence when it comes to clinical evidence of the efficacy and safety of something. and the best that there can be is a randomised controlled trial. There are many, many reasons why, whether they're logistical reasons, regulatory reasons, practical reasons, why randomised controlled trials for medicinal cannabis are not as easily established as randomised controlled trials for standardised single molecule pharmaceutical medicines. So it may not be that randomised controlled trials really ever happen to the level that they might happen for research and development of a standardised single molecule medicine. So what can we do instead is the question. And certainly there is move generally, not just about medicinal cannabis, but generally in the world of evidence, that in terms of drug development, a drug company, spends billions of dollars developing a new drug. They'll have phase 1 clinical trials, which is the first trial in humans, phase 2, where it's the first trial in the target population, then phase 3, when it's actually the target dose, and phase 4 is after it's been marketed out in the general world. Drug companies will only show a regulator that the trials that are, tell a positive story about a medicine and that it's doing the things that they want it to do and that it's safe. The move away from that is, well, let's actually look instead at real-world evidence. Let's look at the data that happens out in the real world, analyse that big data, and then we can determine at a actually more robust way that something is both safe and efficacious. So I think that the solution is to really look at real-world evidence for medicinal cannabis. And given the number of patients that we have at our clinic, we are looking at ways that the real-world evidence can actually be brought forward to properly demonstrate both safety and efficacy. Because it's two things. It's not just whether or not it does treat chronic pain, but it's equally at the same time that it doesn't cause any harm.
Thank you, Mr. McCrone. Just before I go to you, Mr. Murphy, just you talked at the beginning in your introductory remarks about the 70,000 prescriptions or patients in New South Wales that your organisation is aware of, has carriage of. You must have some sort of indication of what sort of cooling effect the roadside drug testing laws have had on accessibility. Like, how many people do you think, can you quantify it, or is it, how many people do you think would be availing themselves of this medicine if they weren't worried about losing their licence, especially in the regions, or they weren't getting that advice from their GPs? Is there potentially hundreds of thousands of more people who could benefit from this legal medicine?
Thank you, Chair. It's always difficult to speak to an exact number in that sense, but what I can tell you is that I've personally, and I know many within our organisation, have spoken to patients who have said they might have tried medicinal cannabis once and found it to be particularly beneficial. They might have been on it for a longer period of time. They might have had their own experiences with it, but they have had to stop, or they have not been able to explore that pathway in treatment because of the roadside drug testing arrangements. And I think it is particularly onerous on New South Wales to make sure that patients in New South Wales who could benefit from a treatment, who are potentially going through severe PTSD or are suffering from chronic pain, don't have a treatment option removed from them because a blood test would show that they were potentially several days or weeks ago impaired.
Chair, we do periodically, if patients choose to volunteer to opt in, we do patient surveys. We have done patient surveys in the past about driving and the impact of the driving laws on their life generally, but on their decisions on when to take the medicinal cannabis and when not to. I'll see if we can get some data for you on that that's specific to our New South Wales patients.
That would be very much appreciated, Mr. McCrone. Mr. Murphy, apologies.
Thank you, Chair. I just want to come back to this issue around Tasmania. When I had a look at Section 6A of the Road Safety, Alcohol and Drugs Act in Tasmania, it seems to be a complete defence as long as you're taking it in a way that's been prescribed under the Poisons Act.
Yeah, in accordance with the Poisons Act.
So it doesn't really engage at all with the issue of impairment. Is there a model somewhere else you can point to that may provide a better way of dealing with the issue of impairment?
Not.
We might have to take that on notice.
You take it on notice and come back to the committee if you can see some other jurisdiction that's got a model that deals with impairment. Other than just a complete defence in the way that Tasmania does.
I will mention again the program that Victorian police officers have had training in for the behavioural impairment test, but that's not. So generally, there are two separate offences. And there isn't driving under the influence, and then there's driving with a proscribed substance.
And look, I just wanted, in terms of work health and safety, to just see if you could expand on your submission on the same issue of impairment in the workplace. So you were saying earlier you would see some sort of division between, I suppose, for want of better words, high risk and low risk in terms of safety. And managing it in that way, but how practically do you see it would operate? Would that mean an employee would need to disclose that they're using medicinal cannabis as a treatment before a testing regime's in place? Or can you just take me through the steps of how you think that might operate practically in a workplace?
Well, I think it's important to first look at the really broad range of occupations where there is testing, and there are whole companies that are able to conduct testing. Within the New South Wales Act, I do believe it allows for any role where there is team-based work, any role where there is, of course, safety-based work, but also where there is tasks that require motor skills. So very quickly, that starts to capture almost the entire gamut of modern working environments, from basic labour-based roles through to knowledge-based roles and beyond. The vast majority of those roles, there would be limited impact if you were impaired, but if you're not impaired but have it in your system, there will be no impact. There are, of course, a few roles. Aviation is a terrific example. Likewise, working with heavy plant and machinery, where we do understand the need for additional provisions and additional protections in place. But if you are an office cleaner, perhaps, for example, and we know of cases where there have been office cleaners who have had THC in their system but are no longer impaired, and who have had a disciplinary action in relation to that.
So you, in your view, you would need to distinguish between occupations rather than dealing with the question of impairment?
I think you also have to come back to impairment. We in no way think that you should be impaired and working, but particularly for those occupations that are higher risk, you do need to be having a deeper look. But for those occupations that are a lower risk, if you are not impaired, then there should be no concern with your ability to do your work.
So to take it further, there's obvious, it's aviation, it's police, it's commercial passenger vehicles, it's boats, anyone, that's in those industries, there's no question.
Any industry could be dangerous, couldn't it? Depending on what your particular role is or the type of work you're tasked to do. I mean, you could be a police accountant where you may be no risk to anyone if you have THC in your system, or if you're slightly impaired, versus a frontline officer about to effect an arrest. It's a completely different situation, same occupation.
Agreed. But these are statutory. So these are what we're referring to is where there are already statutory requirements for those industries. So beyond those ones where there are statutory requirements, we would say that there needs to be a testing regime which is best practice, and I can give you the details of this on notice, but NCETA at the University of Adelaide has developed some years ago what a best practice model of drug testing looks like.
If you could provide that, that'd be great.
But it really, regardless of the best practice model, it still needs to focus on impairment rather than mere presence of a substance.
Chair, just one question from me.
Yes, Mr. Lawrence.
It seems to me that there might be two parts to this driving question. One is the impairment question and whether technology exists to test that. And then the other one is the decision to drive after consumption, whether short-term or medium-term after consumption. And I'm just interested on whether you know anything about advice or technology or understanding around that second part. So, for example, with alcohol, we all are told, we're obviously told that it's not 100% reliable, but we're told, 2 in the first hour, 1 every hour after that. Is there any equivalent formula in relation to cannabis that's emerging that might assist people?
No, because again, it goes to a medicinal cannabis patient is taking medicinal cannabis every day, chronically. So the idea that the amount, for a medicinal cannabis patient who's taking their medicines regularly and every day, there's probably no impairment at all. If there was what's called cannabis naive person who was to take the same amount of cannabis as that medicinal cannabis patient, they would be impaired. Equally, someone who doesn't drink a lot of alcohol, they have 1 drink and they're impaired. But someone who's a fairly regular drinker could have several drinks and not feel impaired.
Yeah. So is that a problem in the sense that, I imagine that the existence of these rough formulas in respect of alcohol operates to keep a fair few impaired drivers off the road, because even though people might get it wrong on occasion, might miscount as well, but by and large there's a bit of an understanding about when you should or shouldn't drive.
Indeed.
If there's not such an understanding with respect to cannabis, is that not an argument to maintain this driving prohibition? Because if we don't, we're asking people to do the impossible in terms of make assessments about when they can drive.
Well, not that I'm saying that this should be the legislative answer, but equally we know when we're too tired to drive. Or, whatever reason, I've had the kids been up sick all night and I haven't slept and I shouldn't get behind the wheel and drive, 4 hours tomorrow because I'm too tired. You make that decision personally, you are aware of your own capacity. And I'm not saying that that is the legal answer, but we are making these decisions every day ourselves. And equally,
we are, except one sort of a natural part of the human condition, i.e. getting tired, and the other's the introduction of an intoxicating substance.
But we do that with other prescription medication.
Yes,
the doctor says,
absolutely.
If you have this, don't drive for 4 hours, 6 hours, 12 hours at all.
So methadone is a very clear example. I don't want to bring this up to cause further stigma to patients on pharmacotherapy, but it is actually stated in policy, doctors should advise their patients to not drive for the first 2 weeks that they're taking methadone. That's a broad yardstick. It's not definitive, it's not exact, but it is to allow them to titrate their dose and to get used to that medicine being in their body.
And is there any similar thing with cannabis, like don't drive for 8 hours or 10 hours?
Well, I'm talking about policies that are issued by governments. The New South Wales Ministry of Health has a policy for pharmacotherapy, equally the Victorian Department of Health. They're certainly not issuing these policies for
They used to say
cannabis
12 hours
in the context of
they
driving.
took that down, I think, off the website.
But Mr. McCrone, is there any research you could point to? I like the Swinburne's done or the Lambert Initiative that in this area. Could you take that on notice?
Yep.
If you could provide us with any research on, a similar comparable scheme where doctors or a researcher may be saying, don't drive after 6 hour or until the morning.
So what Swinburne's done to date has actually been with a driving simulator, and they are patients who have brought their own medicine and they're self-declared about their level of impairment before or after their medicine. What is yet to take place at Swinburne, and everyone's looking to this as being the answer for everything, is actually patients being enrolled and then actually getting in a real car and driving on a closed road. But it seems the results of that trial will not be available until late 2026.
We'll see about that. Look, we're
Sorry,
running
Chair.
a little bit over time. Quickly, Mr.
If I can just ask also, if you're aware, as part of that question that you're taking on notice, whether other jurisdictions have adopted that type of yardstick or they have evidence of it. I mean, it's a problem everywhere in the world that people drive and have cannabis. Maybe you're aware of some other jurisdiction that's come to grips with it.
Thank you. If you could take that on notice, we'd appreciate that. The time for questions is run over a little bit there, so apologies to our next witnesses. But thank you to you, Mr. McCrone and Mr. Strong, for the submission from Montu, for you taking the time to appear today. We very much appreciate it, and for the work you're doing in the community. We really do appreciate that. So the Secretariat will be in contact with you in due course about those matters which were taken on notice. Again, thank you and good afternoon.
Thank you all.
Thank you, Chair.
Afternoon to you, Dr. Jauncey and Ms. Alice Solomon. Before we begin with an opening statement from you and some questions, could you please state your name and position title and swear either the oath or affirmation? And we'll start with you, Doctor.
My name is Dr. Marianne Jauncey. I'm the Medical Director at Uniting's Medically Supervised Injecting Centre, where I've worked for the last 16 plus years. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms. Solomon.
My name's Alice Solomon. I'm the Head of Advocacy and Media at Uniting New South Wales ACT. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you so much. Do you have any introductory remarks Uniting would like to make?
So we appreciate the opportunity to contribute to this inquiry. Our submission includes Uniting's discussion paper, which is the possession and use of drugs options for changing the law, which explores why we support decriminalisation of personal use and possession of all drugs and how this could work in practice. So Uniting leads the Fair Treatment campaign along with 70 partners, advocating for the decriminalisation of personal use and possession of all drugs and an increased investment in treatment. In other words, our campaign supports the removal of criminal penalties for the possession of drugs for personal use and equitable and affordable access to treatment for everyone who seeks it. In addition to the campaign, Uniting's operation of the Medically Supervised Injecting Centre, or MSIC, in King's Cross, led by my colleague Dr. Marianne Jauncey over the last 23 years, has shown the positive result of a health-based approach to drug use. Through MSIC and our Fair Treatment campaign, Uniting has significant interest in reforming laws to ensure a health-based approach to drug use and dependency and better outcomes for people and communities. And as outlined in our paper, most people use drugs and lead very ordinary lives. Nothing needs to be done. And it is the harm of criminalisation that is having the most impact. For a small number of individuals who do go on to develop drug dependency, the current approach erects barriers to accessing help and support. Existing drug laws create unnecessary obstacles, hindering people from seeking treatment, amplifying stigma, and exacerbating the isolation felt from those who might actually benefit from connection. And so when society responds to drug issues primarily with law enforcement rather than treatment and support, it essentially is punishing individuals instead of offering genuine solutions. And it's important to recognise that drug dependency often arises from complex social circumstances, disadvantage and trauma. And therefore responses to harmful drug use and dependency should address underlying causes and refrain from this target on individuals. And it's well established that treatment and harm reduction is effective. By shifting the focus of the system towards providing these services, lives can be saved, costs can be reduced, and law enforcement resources reallocated. And would invite the committee members to engage with Uniting in the Fair Treatment campaign as we work towards the New South Wales Parliamentary Drug Summit. And we urge the inquiry to consider the benefits of more health-focused, harm reduction-based regulatory framework for cannabis and other drugs in New South Wales, and look forward to any questions you may have.
Thank you so very much. We'll start with questions from Ms. Fairman.
Thank you, Chair. Thanks for coming today. Great to see you both here. My first question is just to explore a little bit more the importance of having the treatment programs and other services in place for any decriminalisation model should we get there in this state. We know that some criticism is starting to come out of decriminalisation where it's, for example, in Oregon. But we've also, I think you can speak to this, seen stakeholders say that that's because there hasn't been the required investment into health programs. So why is that so important to make sure that that's right, and what does that look like?
So our campaign specifically asks for the two things, the decriminalisation and the investment in treatment and harm reductions, because of the relationship between those two things. We know that most people found in possession of small quantities of drugs don't need any interventions. But where people are in that moment seeking support and seeking treatment, those services need to be available. And so we can see that playing out internationally, that the combination of these things has been quite important.
And I think people often point to Portugal, and I think there's sometimes the narrative around Portugal is see what Decrim did, but it's actually very clear that what happened in Portugal was not merely the decriminalisation. It was at the same time the really significant investment in treatment and support services, and that I think is not always appreciated, because decriminalising on its own without anything else is not in any way going to be the panacea that some people might magically think it's going to be.
Yes, thank you. Because there's also the huge reduction in days, for example, when somebody, for example, in Portugal, if they're caught with in possession of illicit drugs and need treatment, can pretty much get into treatment within a couple of days, compared to here. And of course, Uniting ran a very successful fair treatment campaign. We still don't have a treatment centre rehab centre in Dubbo, for example. So I don't know if it's any worse than what it was when I was part of that campaign a few years ago in terms of waiting times, but I'm sure it hasn't got any better, if you wanted to talk about that.
In terms of at the front line, I mean, in many ways, working in a metro area already, I'm doing better than a lot of my colleagues that work in regional and rural and remote areas. It is definitely, there's a postcode lottery, in New South Wales. I haven't got a sense that things have particularly changed in the last few years. There are places in New South Wales that you can be waiting, for something like methadone or buprenorphine, so pharmacotherapy for opiate dependence, which is considered essential medicines in any civilised country. You can be on a waiting list for up to a year. So there is very much still an ongoing concern, even if we're better than some other states, that it is still difficult when somebody finally gets to that point of putting up their hand and asking for help, and we've been maybe working with them for some time, and we know already there's a delay of up to a decade before people, after they've run into problems, before they put up their hand and ask for treatment. It just seems so cruel to then have no room at the inn when they finally put up their hand for help.
I wanted to ask about discretionary powers within the police. We got some very disturbing research by NDARC, by Professor Don Weatherburn earlier, about the decline in cannabis cautions compared to cannabis prosecutions over the last decade. My office recently obtained data from the new EDI, Early Drug Diversion Initiative, and that's also very concerning, particularly in relation to ICE, and I know how involved you were with the ICE inquiry. So For example, and I'll just give you one stat and get your view on police discretion, 1,247 people, this was just in the first 3 months, were charged with using or possessing ice, while just 60 people were issued with a fine and diverted into the initiative. Meanwhile, cocaine is different. 258 people caught with cocaine were charged and 99 issued with a fine. So that seems to say that police discretion isn't working, and it's also discriminatory in terms of how they deal with the different drugs. Would you care to comment on that?
So I think from our position and what's in our discussion paper, we think that the issue of police discretion does need to be looked at. We think that that even with the cannabis cautions scheme, you can see that the statistics bear out depending on if you're a First Nations person or not. If you're not a First Nations person, you're 75% more likely to get a cannabis caution. And if you're a First Nations person, you're more likely to go through the criminal system. We think that if part of considering decriminalisation is to also consider the ability of police to stop and search people for possession of a small amount of a drug that is no longer carrying a criminal consequence. We know that discretion is really important to the police that we speak to. The statistics you speak to about the rollout of the early diversion program concerned us. When we were speaking to police, they seemed quite enthusiastic about it, about having another kind of tool in the toolkit about how you could respond to possession of small quantities of drugs. But we know that the issue of stigma is very strong around drugs, and which people.
Which is why I think having a faith-based organisation, and I say this as somebody who doesn't describe herself as somebody who is religious, I think having a faith-based organisation active in this space is really helpful and really important, because we have to change this simplistic narrative that says drugs are bad and people who use drugs are bad, because that plays out across society, including amongst police, who are ultimately obviously just members of society. And so I think, you know, an organisation that is perhaps a bit more familiar and confident about talking about good, bad, right, wrong, moral, immoral, is a good organisation to be encouraging the community as a whole to have a rethink about the way we talk about drugs and the people who use them.
And so the paper that you've submitted as part of your submission, does Uniting have, or the campaign have, an ideal decriminalisation model? So, and I assume police discretion and potentially fines aren't part of that, or could you talk us through what research you've done in the area?
So the paper is options for to consider. So things to think about are questions about thresholds and what at the moment we have what's a deemed supply, and whether we need to think about this kind of reverse burden of proof that a person has to prove that the quantity of drugs were not a supply, and instead put the responsibility on police to prove issues like supply. Questions about what do you do with the drugs, is confiscation what needs to happen, what interventions are appropriate. So we advocate for health and harm reduction based interventions, and fines would be inconsistent with that type of approach. What else?
So I suppose the basis of it, again, which I like, is it's saying we're not saying we've got all of the answers, but what we're saying is that you need to have some underlying values and principles and use the evidence, and those two things should be how you make your decisions rather than ideologies.
I've got more questions, but I'll come back if there's time.
Sure, Mr. Ruddick.
Thanks, Chair. So thank you very much for what Uniting has done over the last few decades, being out there on the front line with people who do need help. So your views are very, very welcomed. So now, but Uniting does support the decriminalisation of all drugs, correct?
Yes.
Okay. Now, so I hear conflicting views about what's happened in Portugal. So my understanding is, I'm happy to learn, about 20 years ago, all drugs were decriminalised. Is that correct? But not legalised.
Yes.
And you think that and there's been a number of changes of government in Portugal, but I think they have largely, despite changes of government, they have largely stuck with that policy. Is that correct? And how do you consider it? Do you consider that to have been a successful case study of what's happened there?
Yes, I would say that even the fact that subsequent governments of different colours and flavours did not seek and have not sought to change the policy in and of itself is somewhat of an indication of the success. There was very high rates of harm and very high rates of use of drugs like heroin back in about 2001. So the year that we opened was the year that they decriminalised drugs. And I think, broadly speaking, there really isn't a lot of contention that it was anything other than a good thing. I think in more recent times, especially with what's happened in the States and elsewhere, there's been some reassessments, and across Europe there has been increasing rates of drug overdose, and there was concerns that some of the investment in treatment was being perhaps undermined or eroded. But, you know, the various architects of the policy have come out again to clarify they are absolutely not suggesting that the underlying policy of Portugal should change. And I mean, I've been there and spoken with police, and interestingly, the police are very supportive of that policy, which I think is really crucial.
Okay, and the last question, Chair. So in Oregon about 2 years ago, there was also a blanket decriminalisation, but not legalisation. Is that right?
Yes.
And but I'm hearing bad reports coming out of Oregon. I'm hearing, you know, a surge in crime and antisocial behaviour. What do you think is behind that in Oregon?
So I suppose very simplistically I'd say there was an awful lot of problems going on already. To expect something that didn't have the corresponding investment in treatment to have any kind of magical powers in a relatively short space of time was unrealistic. And so I'm not surprised, to be honest, that they haven't magically turned things around. There is a mountain of problems going on across North America, and we know that. And I think many of us are desperately concerned that we don't have a similar thing happen across Australia in terms of synthetic opioids, and particularly potent opioids. But as a general thing, I think there was perhaps, again, an unrealistic expectation, a bit like the simplistic thing of they decriminalised in Portugal and everything was okay. That is not the case, and that isn't what happened. And so I think the narrative perhaps got beyond them, that somehow there was this expectation that we'll decriminalise and make everything better. That is not what anybody should expect, and you're going to set yourself up to fail if that's the narrative that's being accepted.
Thank you.
I think, Mr. Ruddock, it's important to note that in Portugal, that regime was brought in by a socialist government and Antonio Guterres, so you'll like that. Whereas the system that didn't work so well was the capitalist system.
It hasn't been
the
reversed.
neoliberal system.
Hasn't been
apparently,
reversed, so that's good.
Allegedly.
I was going to say, I have more questions for the witnesses.
No. Sorry, it's getting late in the afternoon. I've got a question. Dr. Jauncey, could you tell me about your experience of cannabis use in King's Cross? Like, you would deal with a lot of people that have got, you know, poly drug use. How often do you see people that their cannabis use is the most critical thing in terms of their health, and how is, you know, what's cannabis use look like for some of your clients?
I suppose there's probably two things I'd say. The first is that cannabis use is quite common amongst our clients, and the use of plant-based substances in our clients is almost invariably never the most significant concern in terms of their substance use, and often polysubstance use. However, that's not always the case when people have started using synthetic cannabis, and so we've had a couple of clients that I can think of where they really ran into trouble because of the, you know, in an attempt to use something that maybe, you know, wasn't going to be caught or wasn't technically illegal, they were using far more harmful substances than the plant-based products. And so that was a particular concern for them. And the other thing I'd say in terms of the picture in King's Cross, which often really surprises me, is that in talking with police colleagues when we have various meetings with them, and they're reporting about drug-related crime statistics and arrests and charges. And I'm always looking at the figures thinking, gosh, what's the breakdown between heroin and methamphetamine and cocaine? And when I ask questions, I'm always reminded that the vast majority of those are always for cannabis. So even on the streets of King's Cross, the police are spending more time on cannabis than the other substances, which strikes me as a little out of step.
That's remarkable. Remind me, with the medically supervised injecting centre, is that available to people under the age of 18?
No.
No, it's not. In your experience, though, being active in that area, actually, I won't ask that question because it's not. Yeah, if you're not working that area, you're not working that area. The other question I have is, why have you, when we look at places like Oregon, they brought in decriminalisation of all drugs, but they did move to a legalisation regime for cannabis, a full legalisation. They had a referendum of their state and moved. Why haven't you decided that legalisation, made a distinction between cannabis and other drugs?
For us, our motivation in supporting decriminalisation comes from our role as a faith-based organisation, and we are concerned with dignity of the human person, with people experiencing the most disadvantage, for the common good and for solidarity. And the issue of decriminalisation was brought to the Synod. So the Uniting Church is a little bit different to other churches. They vote on a whole lot of stuff, including the position that they take as a church. And the question of decriminalisation and increased funding for treatment was brought to the Synod, and the decision was made to support that for all substances. So the question of legalisation actually hasn't been brought in front of the Synod. Why we say all substances is because our position comes from an understanding that it is the criminalisation of people who use drugs and the criminalisation of people who experience drug dependency that is causing harm in and of itself. And our motivation then is to look at systems that reduce that kind of harm.
Thank you. Mr. Lawrence.
Thanks, Chair, and thanks, witnesses, for your submission. It's really helpful. I've got a few questions. So you might be aware that Premier Minns, prior to the election, ruled out the decriminalisation of drugs. So it would seem, or it is government policy, I suppose, at least for this term of government, that that is ruled out as a consequence of the election. So I'm interested in talking to you about some policy measures that would be short of decriminalisation but might involve a relaxation of the criminal regime. And I just wanted to get your response on some of them. Have you got any thoughts on an administrative arrangement where, for example, the police and the police prosecutors and the DPP prosecutors were given directions not to prosecute minor drug matters as a matter of policy?
Firstly, we look forward to the upcoming New South Wales Drug Summit, and we look forward to that being an opportunity to come with open hearts and open minds to evaluate the evidence and to come with nothing ruled off the table. We think that that's a real benefit of having this drug summit coming up by the end of the year. In terms of measures other than decriminalisation, I think we'd want to be looking at about can we do an expansion of the current diversion scheme, and what can we learn from what's happening overseas. So we know in the UK, in the States and in Canada, there are measures where the police are playing quite a different role in the community around the issue of drug possession, and especially around the complexity of drug dependency. So really leaning into that's being a health and welfare story and not wanting to be in the business of policing homelessness, poverty, mental health and drug dependency. In the ACT, they've passed laws to decriminalise personal use and possession of drugs. What I think is really interesting about that is the way that the police worked very closely with CARMA, which is the peak user group representatives, to kind of design how that was going to be rolled out. And the decisions that police made about how they would then go about policing the decriminalisation of drugs. And so I think there are opportunities where policy can be used. I'd want to see what happened with this current diversion scheme that saw such a low uptake in the police of actually doing that, and make sure that any system that came in was really seeking to address that. We know that part of the harm of the drug laws is the way that police are currently interacting with otherwise over police community. So we want to make sure that it was really bringing in the best options.
Yeah. So under the Director of Public Prosecutions Act, there's a power for the Attorney General to direct the DPP in relation to prosecutions, and there's a power for the DPP to direct the police, I think. And then the Commissioner of Police obviously has broad powers. So I'm interested specifically on what room you see there for administrative policy being used in a legal context where, for example, drug possession and cultivation remains a criminal offence, but as a matter of administrative policy, there are directions given not to enforce particular laws, for example, maybe on condition or maybe absolutely.
I think as a general rule, I mean, you can either change the law and have de jure decriminalisation, or you can have various measures of de facto, which is kind of getting around it and being practical. And look, if we can't have one, then I think as a general rule, it would be something that we would be interested in working out, well, in practical terms, what can be done to reduce the impact. So I don't know the details of what you're talking about, but as an in principle response, yes, I would be, approving of something that overall is going to reduce the impact of the personal use of possession in terms of criminal responses to people, where those criminal responses are just wildly out of step and do nothing to help them in any way, shape or form.
Yeah. So we've taken evidence in support of the suggestion that the Law Enforcement Powers and Responsibilities Act should be amended to remove the power in police to search people on suspicion of small possession of illicit drugs. What's your thoughts on that?
When we speak with police, they are looking for a broader range of responses that they can have when they find someone in possession of a small quantities of drugs. When we speak with police in Portugal, they kind of laugh at the idea that you need stop and search powers to find drug traffickers or sort of high-end drug organised crime kind of powers. We know that, for instance, for First Nations people, it's right at the point of contact with police, to the decision to charge, to appearance in front of court, to bail decisions, to sentencing decisions, where First Nations people are having a disproportionate negative outcome compared to other parts of our community. And so looking for opportunities to decrease police interactions that are not grounded in solid need and concern for harm for that person or for the community, I think is worth exploring.
Yep. So what's your response to this idea or reality that people are being strip searched, including children, on suspicion of the possession of a small quantity, for example, of cannabis, but it could be some other drug? What's your response to that on a human level?
I'm appalled.
I'm horrified.
On a human level, I'm absolutely, utterly appalled.
So do you see any legitimate policy reason why police should retain a power to search a person on account of suspicion of possession of a small quantity of illicit drugs?
No, I don't. Because the position of Uniting is that the personal possession and use of drugs, so small quantities for personal use, should not be a crime. And if it's not a crime, then why on earth should the police have the right to search you?
Yeah, I mean, some people would respond to that and say, well, for so long as it is a criminal offence, there should be a power to search for it. And I'm interested in your response to that. Like, why is it that something might remain a criminal offence for an indeterminate period of time, but in that interim period, there ought not be a power to search for possession of it? How would you justify what some people might say is a discrepancy in that respect?
Our approach to drug use and possession is one of harm reduction. When people are stopped and searched by police, when that is shown statistically to have very low success rates in identifying or finding possession of small amounts of drugs, when that's coupled with things like strip searches, which are being conducted kind of outside the boundaries of when strip searches should be utilised, I think we need to ask ourselves what harm has been caused in the way this is being policed. And given that has very low success rate in what its stated aims are, I think it's inconsistent that be allowed to continue as a practice.
Sure. And what are your thoughts, and I think you talked about this, Alice, in your evidence, but is there work to be done short of decrim in the thresholds at which something is deemed to be supply, and also the definition of supply, in the sense that in New South Wales, a drug dealer who's dealing for commercial purposes and a person who gives a tenner to their friend is actually caught by the same criminal offence. It might be different penalties, but they're caught by the same criminal offence. Do you think there's work to be done in that harm reduction space in terms of looking at those elements and thresholds and relaxing the existing criminal regime through that?
So currently, it is the quantity of drug you are in possession of that says whether it's personal use or supply. And we argue that that's an improper way to go about making that assessment. So we know, for instance, our clients at MSIC will have personal use for them will look very different to other people who are casual drug users. Some people might buy their month's supply. If a casual user might buy a month's supply, a casual user might buy supply in terms of a social supply where, I'm buying for myself and a friend. And that when we're looking at non-personal use, then the responsibility sits with the police to show supply, and then other elements should be called in to demonstrate that this is supply beyond the kind of reverse guilty until you prove yourself innocent that we kind of have in the way that we deem supply right now.
Yeah.
I think that's really crucial, because I remember when I first came into this sector and, didn't have, I'm no lawyer, but, the underlying tenet of our law is innocent until proven guilty, and then you sort of dig under the surface and you start talking to clients about their experiences and you think, hang on, it's not innocent until proven guilty, because if I'm this much over and it's the total weight, not the weight, the absolute weight. So if you've got a certain amount of white powder and 90% of that is salt or bicarb or something, doesn't matter. It's not the absolute quantity of the drug, it's the total weight of the substance, and nothing else needs to be done. So it literally is guilty until proven innocent. I was really shocked when I first understood that, and I don't really have an explanation for it because I'm not aware of that operating in other areas of the law. And again, it's this thing where the narrative around substances and the people that use them needs to change, because our mentality is it's all bad. And I think that's where we really need to shift our thinking.
So right now, the maximum penalty for mere possession of drugs is imprisonment for 2 years. Now, obviously, a criminal offence that carries a fine only is still a criminal offence. So within that rubric of continued criminalisation, what do you think is an appropriate maximum penalty for possessing a small quantity of drugs, not for supply? I mean, should it be a fine? Should it be 3 months as a maximum? I mean, you obviously advocate decriminalisation, but in an interim period, where would you relax it to have an interim process in that respect?
Harm reduction principles. If you're applying harm reduction and health-based responses, just to be clear, we don't think fines are health-based responses. What you want to do is increase people's opportunity to access support. So if you imagine, many casual users of currently illicit substances are, otherwise living their ordinary lives, can probably manage to go to court, go through that kind of process. But in and of itself, that is a harmful and difficult thing for a person to go through. We put our young people at risk of future employment, opportunities, future travel, those kind of things. And then for people who are experiencing drug dependency and have other life challenges that are happening, are less able to fight off those or defend themselves in those kind of circumstances. So we would be looking at what an expanded diversion system might look like, having more than 2 opportunities for somebody to be able to access information or access a treatment service or those kind of options. And we would be looking at how do we make sure that that is embedded in the policing practice, that like what's happening in the ACT, where police are like, I don't want to be chasing after people for a $100 fine.
So just on that, we took some evidence earlier that to the effect that there shouldn't be any regard in the cautioning or diversionary schemes to prior matters, and the analogy was given to traffic matters where inside of the point system you can continue to commit traffic offences and your eligibility for a ticket doesn't depend on whether you've had one before. There might be some circumstances in terms of good behaviour bonds that the RTA or RMS imposes where they might have regard to whether you've had one before in terms of the conditions and so forth, but overall the scheme doesn't have regard to how many prior matters you've had in that respect. So would you agree that either the cannabis cautioning scheme or something of that nature, some future scheme, actually shouldn't have regard to prior matters, and you certainly shouldn't be ineligible on account of prior matters?
We think the question of eligibility is really important, and that there shouldn't be kind of eligibility criteria to be able to access diversionary type schemes or decriminalisation.
I think as a general rule, most people who use drugs don't need treatment for their drug use. So the first few times that somebody's coming into is found, for example, they don't need to be referred for treatment. I think there's a misunderstanding that somehow they have a problem and we need to fix them. That's actually not right. But I do think, again, as a general rule, for example, if you're picking up somebody, who clearly has problematic dependent drug use, then I think there is some kind of overall narrative that says that, the more frequently you're picking up someone, the more likely it is that there's an underlying problematic or dependent drug use, and the more appropriate it is to try and offer them assistance and support and treatment.
So just lastly from me, would you support amending the sentencing law so that the default position is that a person is not convicted for drug possession and they can only be convicted, for example, if a threshold test is met, the court's satisfied there's exceptional circumstances or something of that nature?
We haven't explored that. Happy to come back to you.
Sure, if you wouldn't mind. And if you wouldn't mind taking on notice any other measures that you think might be good as a relaxation of criminalisation, short of full decriminalisation, respecting your ultimate position, of course, on decriminalisation.
Just a last one.
Yeah, I'm aware of the time. Sorry, Chair. I am keen just to get a little bit more information on the record about the, you make specific mention again in your submission about Section 29 of the Drugs Misuse and Trafficking Act in terms of deemed supply. You use the example of heroin. An amount greater than 3 grams of heroin is deemed supply. You want to reverse the onus of proof, which happens in other jurisdictions. Why have you put that into this submission? Why is that important in terms of reducing harm? As in, what's some of the problems with that, which I think you outlined in your submission? I do just want to get some more information on the record.
From a very practical point of view, you've probably got a better theoretical, but I see, the people that are coming to the medically supervised injecting centre are not the kingpins of drug trafficking in Australia, and I see them getting caught up for what is personal use. People doing the go-between, and if they do that 3 times and they earn $10 each time, then they're, caught under all sorts of what is thought to be significant trafficking kind of activity, whereas when in reality you know what's going on for that individual, there's just an absolute mismatch. So
and it's
for me,
and it's inflexible as well, right?
Yeah, so even when the individuals understand within the court what's going on, because of the laws, and they've got to stay in their lane, this is what then is the inevitable outcome, even when everybody acknowledges that it's nonsensical.
Yeah.
Thank you very much, Dr. Jauncey.
changed.
Thank you very much for your evidence you've given today. It's of enormous value, and for the submission you've provided to the inquiry, again, very valuable, and for the work you do in the community. It's very much appreciated. We look forward to seeing you at the drug summits very soon. I think there were some questions taken on notice. The Secretariat will be in contact with you in due course regarding that. But once again, thank you very much and good afternoon.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.